wasn't going to come, but it was.
Today?
I went to work and there. Go ahead. Taped all over. So they put some on my binder. They put funny things. There's one that was going like this, playing, and it said invisible roller coaster. Ready? Okay. Okay. Is it on? Thanks. Good afternoon and welcome to the regularly scheduled meeting of the Sunshine Ordinance Task Force for February 28th, 2012, and we are starting just after 4 p.m. I would like to welcome our new administrator, Andrea Osbury, and if you would please call the roll.
Member Snyder?
Here.
Member Nee?
Here.
Member Catherine? Absent. Member Money? Absent. Member Washburn? Absent. Member Costa?
Here.
Member Chan? Member West?
Here. Here.
Vice Chair Wolf? Absent. Chair Johnson?
Here.
We have a quorum.
Okay, so we have, Member Manet will be here, but she wasn't sure exactly what time she would be able to get here. And Member Washburn is currently out at a work conference out of town, and Vice Chair Wolf has been ill and will be on leave for some time. Is there a motion to excuse members Washburn and Wolf?
Second.
Is there any public comment on the motion to excuse the members? Seeing none, public comment is closed. Can we do that without objection? Okay, seeing none, members Wolf and Washburn are excused. I would also just quickly like to say we have a different deputy city attorney sitting in until about 6 p.m. This is Michael Carnes, and then DCA 3 will be back around 6 p.m. this evening. So thank you for assisting us. And then we have just one, I believe just one potential agenda change, and that is items 17 and 18, which is complaint 11091, the hearing on the complaint filed by Nick Pasquarello versus the Office of Supervisor David Chu. The complainant telephoned, did he call you or?
He called the front desk.
Called the front desk to say that he would not be in attendance this evening, but we're not certain if he was requesting a continuance or exactly why he would not be here. Did you hear back from Mr. True?
I have not, but I did not, but I did email him to let him know. Today is the full board meeting. I know he's busy with that.
Okay, so I'm not sure if the task force wants to continue this or if we want to wait and see if Mr. True comes, although I believe he monitors whether or not he should come and see us about it. This has been on the agenda a couple of times. Once it was continued because of it being very late. It's 11091 at 17 and 18. So if I don't hear a motion to continue it, but I might suggest we continue it not to March 7th, but potentially to April and see if we can. Mr. True has indicated a couple of times that he provided documents. Maybe the administrator could check with that before we move it. The only reason I wouldn't necessarily want to say to March 7th is we have a number of items to catch up on. We have about 10 complaints in addition to what's on here, but it's up to the task force.
Madam Chair.
Member Neem?
Through the chair, perhaps to Ms. Osbury, what reason did Mr. Pasquariello give for not being here today?
He did not give a reason. He just left a message to the front desk saying he would not be in attendance.
We could also table it and bring it back if,
And tabling, refresh our memories, has what effect?
I believe we have the opportunity to bring it back at the next meeting.
That would
And
be,
if not, then the matter is closed.
and that would be the next meeting is March 7th.
Yeah.
You can continue to the call of the chair, which leaves it open to a date uncertain.
Is there a motion to continue it to the call of the chair? Or do you want to,
So move.
is there a second? Okay, is there public comment on continuing the case to the call of the chair? Okay, seeing none, can we do that without objection? Okay, seeing no objection, then we will continue case number 11091 to the call of the chair. Ms. Osber, if you could try to find out from Mr. Pasquariello if he is intending to withdraw his complaint or if he's received the documents that he requested. Because at the time he filed the complaint, he said he hadn't received any documents. I believe that's it for agenda changes. Do any of the task force members have agenda changes? I do have one more question, Ms. Osbury. Have you heard from Mr. Pitts, the complainant in 11094? That's items 21 and 22. I don't see Mr. Pitts here.
I did not receive word from him whether or not he would be here or not, but he did email with an additional amendment to a document that provided.
On here?
Yes.
Okay, because there's some question as to whether or not we have jurisdiction to hear the complaint. It's a nonprofit, and the complaint involves it involves only 12L, which has to do with financial records, and the documents that he's requesting are not financial records. Is the respondent here from 11094? That's.
Hi, good afternoon. I'm Jeffrey Kohler with Community Housing Partnership.
Okay.
In this particular case.
I don't know if we want to wait a few minutes since it was toward the end of the agenda. Maybe we could wait a few items and see if Mr. Pitts arrives. Otherwise, we might want to consider the jurisdiction item. Are you guys contesting jurisdiction?
No.
No? Okay. So I guess we'll see if Mr. Pitts arrives. Since he did, it's more toward the end of the agenda. But if we don't have jurisdiction, I didn't want you to have to sit here until the very end. So we'll try to fit those particular items in when Mr. Pitts arrives to see if we do have jurisdiction. So that's items 19 and 20, and I wanted to make that announcement early on so that people could be aware of that.
Okay, it's my understanding he won't be here, but I'm happy to wait to see if he does.
Okay. Did he contact you?
No.
Okay. So we'll just give him an opportunity to appear, and then we'll talk about the jurisdiction.
Okay.
But
fine.
won't have you sit here the entire time.
Okay, thank you.
Thank you. Okay, if you could read the next item, Ms. Osprey.
Item number 2, approval of minutes from the October 25th, 2011 regular meeting.
Move to approve.
Second.
These are the minutes that we had, these are the changes that we had approved previously, adopted previously, and everybody wanted to see in their completed form. I personally just have one single thing that I saw. It's on page 10 of our packet, if they're numbered, and it's in item 6, file number 11042, the second paragraph. It says complainant was not present. The second sentence says respondent stated some document. It should be documents because it sounds like some document had been provided. So just plural. Other than that, I have no other changes. Are there any other changes by the task force? Is there public comment on the motion to approve the minutes? Okay, seeing none, public comment is closed. Can you call the roll on approving the minutes?
On item number 2, Member Snyder,
Yes.
Member Nee,
Aye.
Member Costa,
Aye.
Member Chan, Member West,
Aye.
Chair Wolf.
He's not here.
I mean, I'm sorry, Chair Johnson, sorry.
Here.
Okay,
I mean, yes.
okay. You have 6 ayes.
Okay, can you please read the next item? So the minutes are approved. Can you please read the next item?
Item number 3, approval of minutes from the November 29, 2011 special meeting.
Is there a motion to approve the minutes?
Madam Chair,
Member Nee?
for a couple of reasons, I don't think these minutes are ready for approval. Therefore, I would move to continue them until our next regular meeting of March 7th.
Is there a second?
I'll second.
I also agree with that. The minutes, the December 14th minutes, I think are in better, a little more as we had requested them. Is there any discussion on continuing November 29th minutes? Was there public comment on continuing the November 29th minutes? Okay, seeing none, public comment is closed. Member Nee?
Yeah, just a brief explanation. There are a couple of things there. In item number 6, the roll call vote says, on that paragraph says, the motion as amended carried by the following vote, and the amendments to the motion are not identified. Also, in item, just a misspelling, but that needs to be corrected too. In item 20, second paragraph, Supervisor Wiener's name is misspelled. It should be W-I-E-N-E-R.
Okay, is there any objection to continuing these minutes? Seeing none, can we continue the item 3, the November 29th, 2011 meeting minutes to March 7th without objection? Okay, so those are continued.
Will there be public comment on the substance, since Member Nee just commented on the substance, and I have a brief comment on the substance?
No. Can you please read the next item?
Item number 4, approval of the minutes from the December 14, 2011 special meeting.
Member Dean?
Move to approve.
Second.
Member Dean?
Yeah, there are, I believe, some edits that are going to be needed, but they're not really substantial, so I think it's okay to note what the edits should be and then approve. In item 5, paragraph 2, line 3, Mr. Matos' name is misspelled, should be M-A-T-T-O-S. Also in the same item, the motion paragraph, I would reword slightly. That's item 5, packet page 38, I believe. Let me see. Maybe I'm looking in the wrong spot here. Oh, I'm looking in the wrong. Bear with me, I was looking on the wrong page. This should be page 30, I think. Okay, yeah. Third paragraph on that page, page 30. Chair Johnson, with member Costa's support, withdraws motion based on Mr. Piccirillo's comment. The motion was not based on Mr. Piccirillo's comment. I think the withdrawal motion was. So my suggested wording would be substitute the words based on with because she agrees with. Withdraws motion because she agrees with Mr. Piccirillo's comment. Item 9, again in that same set of minutes, in the motion paragraph, this is on page 32. No, page 31. No, page 32. Okay, on the third, on the next to last line of the motion paragraph. This is at the top of page 32. It says section 67.3 D45, and I believe there should be the word "and" between the numerals 4 and 5. And last but not least, in item 17, the final line of that item, he also said Ethics Commission's response to his complaint was proof that it did not want public input in their minutes. Ethics Commission is a singular noun, therefore the word "there" should be changed to a singular pronoun. It's, ITS. Again, those edits are not substantial, so substantive, so I think approval is appropriate here.
Okay, I have one that's not substantive, and that's there's a couple of places throughout where there's parens missing where the times are and each item title. That's not a big deal, but there is one substantive change, and it's on page 30. It's item number 7. The motion is about the 150-word statement. So I believe that in that the fourth paragraph down, the third line from the bottom, it should be section 6716, not 15. But other than that, that's it. Are there any other comments from the task force? Okay, seeing none, is there public comment on the minutes for December 14th, 2011?
Yes. Peter Warfield, Executive Director, Library Users Association. Thank you for having these minutes and for the decisions in items 9 and 11. However, I think these can and perhaps need to be clear. On page 32 of your packet, page 5 of the minutes, at the top of the page, under item 9, Vice Chair Wolf, seconded by Member Nee, motion to find the Arts Commission in violation of Section 67.14C for failing to record meetings of the Visual Arts Committee, which is a policy body under Section 67.3D45, and to send a letter to the City Attorney's Office regarding the enforcement of Section 67.14C. I think the last statement there is rather too kind and very unspecific with respect to what you found. You, in fact, I think, were shocked that the city attorney apparently hadn't heard of this section, which clearly made a subcommittee of a charter-mentioned body subject to having to have recordings. And you were going to send a letter, which I haven't yet seen, nor have I seen the order of determination. You were going to specifically send a letter to the city attorney chastising them for bad advice that appeared to be the result of not having an up-to-date copy of the Sunshine Ordinance in hand. And I think that that needs to be much clearer here than to paper it over in a very vague way. I think that's crucial for people to understand and for it to be clear what that letter was about. With respect to item 11, which was our complaint, the complaint actually was that the Library Users Association did not receive from the Arts Commission draft minutes of a meeting as promptly as required by law, rather than that we didn't get them ever at all. So I think that would be helpful to clarify on that one. Thanks very much.
Mr. Warfield, I have to, I can't go into the details of it right now because it's not on the agenda, but there may be some issues with file number 11084 that were only recently discovered because in the supporting documents and in our discussion, there was no reference made to the Visual Arts Committee meeting outside of City Hall. And Section 1614C applies only to bodies that meet within City Hall. So I may be requesting a rehearing of that particular item. I can send you a draft related to the 11085 of the order, which is out for people to review, and you'll get an idea of what's going on. I can't go into it now because it's not on the agenda, but I wanted to let you know that.
Thank you for letting me know. I certainly hope that we will be able to make the case, which we actually did, which is that when we spoke, we did not refer to the additional item, but said that it would be a gross violation, really, of certainly the spirit, if not the letter of the law, to allow such kind of circumvention strategies to occur, namely to put the actual work of a charter-named body into a subcommittee and then simply rubber stamp it at that meeting, having had the subcommittee doing all the substantive work in whatever fashion it did it in such a way that it wouldn't be subject to the law. Thank you.
Thank you. Is there additional public comment on the minutes for December 14th? Seeing none, public comment is closed. Is there any additional comments from the task force? Okay, can you please call the roll on that particular item?
On item number 4, Member Snyder,
Yes.
Member Nee,
Aye.
Member Costa,
Aye.
Member Chan, Member West,
Aye.
Chair Johnson.
Yes.
Okay. There are 6 ayes.
Can you please read the next item?
Item number 5, approval of the minutes from the January 3rd, 2012 special meeting.
Move to approve. Madam Chair?
Member Nee?
Yeah, again, this is a case of numerous edits being appropriate. However, none of them is substantive, so I think approval would be appropriate. Let me just very briefly go through what those edits are. First of all, throughout the minutes, in public comment sections and in public comment paragraphs, names of speakers, members of the public, are incorrectly followed by a comma or by a semicolon. Those should be removed.
Member Nee? I don't mean to interrupt you, but I have a question about your, to me, you were saying that you think that the minutes should be approved, and we were going to go, before you go through a list of them, every single one of these says provided an overview and requested to dismiss, or said they spoke. There's no detail at all. There's nothing in these minutes that says anything about what any of these things are about. Do you see what I'm saying? It's all really generic. It says David Pilpel spoke expressing various concerns. Ray Hartz expressed various concerns. And then if you go to any one of the descriptions, like item 14 or 15, it says anonymous provided an overview of the complaint and requested to find a violation. Various concerns in support of the complaint, provided an overview of the defense, and every single one of them is generic. Now, this has been going on for some time, and in my time on the task force, I've been trying to put in some kind of information because, like any other, as a quasi-judicial body, we're making these decisions, and we'd like to have some continuity of decision. We would like to be able to go back, and if we have a different DCA person here, we'd like to be able to show our reasoning. So that's why I had been going back and trying to add a line or two so that people would have an opportunity to search, to do various kinds of research. That's why I took the orders of determination and made them have a little bit more of our reasoning in it. But I'm just one person on the task force, so I just want to, the clerk's office has indicated they'd like to have some kind of a standard to go by. My preference is to have, and this has been ongoing, which is why a lot of our minutes are not approved, is to have some kind of, even if it's one sentence of detail. So like in the October minutes, for example, in the Cynthia Carter case, I just had added that some documents had been provided between the two meetings, and that way our motion didn't make it look like we were sort of crazy. I don't know what the preference of, this is a different makeup of the task force than it was before, but when you go back to look at things or compare what you did at a different time, if there's even the smallest bit of detail about what it's about, it makes it a lot easier.
Madam Chair?
Member Neem?
Actually, I agree with you. I believe I have, in the past, raised the same kind of issue, and so I would certainly tend to agree with what you've just said. There is more thoroughness, I think, desired than what we have here before us. But there is a motion on the floor in a second. So if the chair will permit, there are some other things that I would like to point out because I think they will. I think they need to be addressed. In item 1, paragraph 5, line 2, Chair Johnson announced that file number 11086 should be was withdrawn, not were withdrawn. The item numbers 19 and 20 appear in parentheses. The actual subject in that sentence grammatically is file number 11086, so that should be was withdrawn. Also, in the second sentence, I would reword that a bit to say, Chair Johnson indicated that a request from the respondent that file number 11091, et cetera, be continued, and then delete by the respondent. So the words from the respondent should be inserted after request in the third line of that paragraph, and then the words at the end, the words by the respondent should be deleted. In item number 6, in the motion paragraph, the comma after the word committee should be deleted. In items 19 and 20, both of those, paragraph 2, line 2, again, was withdrawn, not were withdrawn. In item number 22, the motion paragraph, I think, is poorly worded. The phrase based on not identify leaves me with also back in line 5, in item 5, the paragraph starting with my name, member Nee, line 6 of that paragraph, the word standard should be standardize. IZE should be affixed to the end. Again, item number 22, which is in packet page 43. Vice Chair Wolf, seconded by Member West, moved to find violation of Sunshine Ordinance Section 67.21C, comma E. That should be C and E without the comma. Based on not identified the existence. What does that mean, based on not identified? That needs to be reviewed and fixed. And then finally, the last phrase in that paragraph, and referral to Compliance Amendments Committee, referral should be changed to refer, and to refer to Compliance Amendments Committee.
Is there any additional discussion? Good. I don't know whether we should take public comment first, or I don't know whether we should take public comment, or I'm going to offer a substitute motion to continue these to try to add some detail to them.
I believe a substitute motion first would be appropriate.
Okay. So I'd like to offer a substitute motion to continue these to March 7th to add some kind of a little bit of detail. Does the second accept the substitute motion?
Hanley was the second.
Oh, you did? Okay.
He was the second. I don't know if he accepts or not.
Was it you? Was it Jackson? Oh, sorry, we were looking at Hanley. Okay. So is there public comment? It's a substitute motion to continue these. So is there public comment on the motion or on the substance of the minutes?
I've been coming to these meetings for, 5, 6 years? And I can't explain the feeling I get after listening to editorial comments that take 10 or 15 minutes that should never have been in the minutes in the first place. The problem has been that the persons responsible for writing the minutes, the quality has slowly but surely deteriorated to the point where even action minutes were no good. This position is an Executive Secretary 3 position. And if you look at the job classification, that requires quite a bit of skill. So all you have to do is to compare the quality of the minutes that come out of this task force administrative office with that of the Ethics Commission, with almost any other of the boards or commissions, and you will find that there is absolutely no comparison. They're not even in the same ballpark. So the problem is not, as Mr. Member Nee suggests, a matter of grammar. It's the whole professional level of the minutes, the person responsible for the minutes. I will have an opportunity to talk about the other aspects of this later on, but I really think that's where the problem lies, and unless the professional level in that spot is appropriately filled, you're never going to get a decent set of minutes. Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. And I will concur with Mr. Grossman's comments and say that, yes, bottom line is if you're paying somebody what the salary that somebody gets at this executive level 3 position, I think you could expect a certain level of performance to be acceptable. But I also would like to bring to the fore the conflict between what this board, this task force wants in its minutes and what the clerk of the board seems to be telling to the contrary to the person who they supervise. And I think, unfortunately, part of Mr. Rustam's problem in the past was he was caught between the rock and the hard place between you wanting good, solid minutes that served your purposes and him being told, no, you're not going to do that. You're going to do what we want you to do, which is action minutes. And very frankly, I think that is the attempt of the clerk of the board to wrongfully interfere with the operation of this task force by telling it what its minutes should be. They're your minutes. You decide what they should be. They need to meet your needs. And if you decide they need to be more detailed, then that's what should be the deciding factor. And the bottom line of the clerk coming in and saying, no, I'm going to tell you that you don't need this, when she has absolutely no idea as to the reasoning behind you needing more effective minutes, is ridiculous. Another thing is minutes are intended to, number one, make a factual report of what goes on in a meeting. They also serve the purpose that if members of the public are unable to attend, they are able to go back and kind of get an idea as to what happened in the meeting. And that idea should be just like an agenda item. It should be done in a way that a member of the public of reasonable intelligence can read it and say, well, I kind of see what they're saying, but I need to go back and listen to the tape because I really want to see what the discussion was around this. And those action minutes don't do that. They provide no way of a member of the public or anybody else using those minutes to go from what you actually have in the minutes to an awareness of a need or a desire to go and listen to the actual tape of the hearing. And I think one of the obligations I've said to many boards and commissions is that it is their responsibility not just to allow public participation, but to encourage it. And I think having these more effective meetings with detail serves your purpose in getting your job done in not only that particular issue, but in ongoing issues, because we know these cases have a tendency to keep popping back up. but it also serves a need of the public to be aware of what's going on here. And I think it needs to be just very clear that the task force, in my opinion, should say to the clerk of the board, keep your nose out of our business. There are minutes. We will do them the way we want to do it. And if you don't like that, we're willing to listen to what you have to say, but we're not going to bow to what you say.
Good evening, task force members. Thomas Piccarello. I'll spell the last name for the new administrator. It's Picarello. I would agree with the motion to continue. The minutes are not specific, nor are they timely. But I don't put the fault entirely on the old administrator. You'll recall, in September of last year, I filed a complaint against the clerk of the Board of Supervisors under 6717, saying that she's not complying with the Sunshine Ordinance under 6717 for having adequate timely minutes. You, in your collective wisdom, denied that complaint. You said she was. Subsequently to my complaint, you have not approved any month's minutes enacted by the board, the clerk of the Board of Supervisors through their administrator. So the fault lies as much with the task force as it does with your old administrator. So I support the motion, but if you look at the clerk's minutes for the Board of Supervisors, they basically identify the person who speaks the public comment and says they express their views. So obviously the clerk has a different viewpoint as to what is required under the Sunshine Ordinance. So all the more reason you should have found that the clerk of the Board of Supervisors was in violation of 6716. Thank you.
I think
I don't think they're done with public
for
comment.
the benefit of Mr. Piccarello and the clerk, the spelling of Mr. Piccarello's first name also is unusual. No H. It's just Thomas.
You may continue with public comment.
Peter Warfield, Library Users Association. I support the motion to postpone action, particularly for the reasons that the chair has enunciated. And I think that previous speakers on this matter, including most particularly Alan Grossman and Ray Hartz, have made many of the points that I would make. I think, well, there's a Yiddish word. It's a Schande. It's a shame that the task force, which is supposed to be the public's way of getting justice under sunshine, and is supposed to be helpful in providing folks who are not lawyers and are not necessarily technically and legally trained in the law and in the history of what's been going on here, you are supposed to be their chance for justice. And when you look at these minutes, many of them, it's impossible to know what actually happened. Who did what to whom? What was the complaint about? What was the action that was taken that somebody found objectionable? Why did you agree or disagree? What kind of back and forth discussion was there? As others have said, many other departments whose minutes I have seen are much, much fuller with detail and with something that an ordinary person could understand, much more so than many of these minutes. Now, with respect to encouraging the public, I commented on minutes some time ago. I gave an impassioned speech about who am I? Am I a member of the public here, or am I an audience? And now I'm seeing that page 33 of the previous minutes, December 14th, even though I believe at least one member of the task force agreed with me on the importance of the terminology, and even though I think the task force agreed to change the term and change audience to member of the public, on page 33 of your packet, page 6 of December 14th, the complainant, under item 14, the complainant was not present, no one in the audience presented facts and evidence on behalf of the complainant. Well, what happened to what seemed like task force agreement with an issue that had come up previously on minutes discussed previously? It seems to have gone poof. I really think that you need to insist on the level of support that you are guaranteed in your Sunshine Ordinance. The clerk is required to give you necessary support. Thank you.
Is there additional public comment on the minutes or the motion to continue? Okay, seeing none, the matter is back with the task force. Can we take the motion to continue without objection? Okay, so seeing no objection, the minutes for January 3rd, 2012 are continued to the March 7th meeting. Can you please read the next item?
Item number 6, approval of minutes from the January 24th, 2012 regular meeting.
Member Need?
Madam Chair, I move to continue these. There are numerous errors, some of them substantive. These minutes, as I see them, are not ready for approval.
Okay. Member Need?
Yeah. First off, one of the lesser important items, although it certainly does merit change, in item 2, paragraph 4, it says Member Nee motioned to continue the minutes but died for lack of a second. I don't recall having died. Somebody wishes to correct me on that, I'd be glad to listen. I would insert the words the motion between but and died. More important, item 3, paragraph 3. This is the motion paragraph. Member Washburn, seconded by Member Nee, motion to have the Rules Committee review it before placing it on the February 28th meeting agenda. Which Rules Committee are we talking about? Task Force Rules Committee, Board of Supervisors Rules Committee, which one are we talking about? And in the second line, review it. What does it refer to? There is no clue on that. Item 6, paragraph 3. This is on page, packet page 50, 50. Wait a minute. Oh, public comment. Ray Hart expressed his view. That is not adequate. This is a specific agenda item, and on specific agenda items, where there is public comment, a summary of that comment is required, 67.16. Item 8, paragraph 2, please delete the commas after unidentified and after Hart's. Items 9 and 10, this is substantive. There is no identification here of which violations were alleged. And there were several sections in the complaint that were alleged to have been violated. They should be identified in the minutes as well. These were items 9 and 10. Item 15, paragraph 2, delete the S in Julio's. His name is Julio or Julio. In item 16, paragraph 2, complaint should be complainant. In the paragraph starting with Joy Houlihan's name, I believe in the phrase transiting personnel, I'm wondering if that should be transit personnel. Should the ing be in there? Should that be deleted? Again, some of these changes are substantive, and that gives me reason to move for the continuance.
Member Costa?
On item number 16, I am marked as absent when I believe I was present on the vote. And also on number 3, the same line that Chair or Member Nee brought up about, was it item 3? What was the public comment? What was the Ray Hart's?
Say that again.
Item number 6. Paragraph 3, it should be public comment, Ray Hart's, not Hart.
Is there public comment on either the substance of the January 24th minutes or the motion to continue them to the next regular meeting?
Yes, Peter Warfield. I hate to disagree with anybody, but clearly the writer of these minutes, contrary to Member Nee's opinion, has differentiated between, for example, item 5, Peter Warfield expressed his views, but on item 6, Ray Hart expressed his view. Clearly, that differentiates between what Mr. Hart said and what I said. Speaking seriously, these minutes, and I'm glad Member Nee brought it right up, don't even meet minimum requirements of sunshine and would deserve a vigorous sunshine complaint for your failure to summarize what members of the public have said, as you are required to do under your ordinance, and you haven't done that in numerous examples which go on and over and over again here beyond the ones that I've mentioned. I've said it before, I think that these minutes should be excellent minutes, they should be exemplary minutes, and examples to everyone else about how to do minutes that really elucidate, make it clear what's been going on, what's been discussed, what's been acted upon. And these are not only not exemplary, but they are a disaster that doesn't even meet the minimum requirements of the very ordinance that you sit here to watch over and enforce. Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. And just a quick thing, comment on Member Nee's report. Mark Twain was quoted, and I hope I get this right, "The reports of my demise are greatly exaggerated." So I think that's very apropos for what you said.
Thomas Piccarello again. I'm in favor of the motion, obviously. But if I understood what Member Nee said about the public comment section of your minutes don't have to be as specific as actions on your agenda, I disagree. I think public comment is probably more critical, and they should be more specific and elaborated in your minutes than discussions on actionable items. Your January 24th minutes regarding public comment just identifies a speaker and it says expresses their views. I think it's very important that the members of the public that aren't here and don't have the ability to watch these proceedings should know what members of the public that are here are saying when they give public comment. Thank you.
Madam Chair, let me respond to that. What I said was agreeing with what you said, Mr. Piccarello, that as a matter of fact, when members of the public comment on a specific item, what they say, a brief summary of what they say, should be reflected in the minutes. That is under 6716. Your remark did not disagree with mine. Your remark agreed with mine.
Okay, so seeing no further public comment is closed. Can we take the motion to continue the minutes without objection? Okay, seeing no objection, the minutes for January 24th are continued to the March 7th meeting. At this time, it's 5 p.m., and we normally take public comment on items not on the agenda at 5 p.m. So this is public comment. You'll have 3 minutes for items not on the agenda.
I have 3 minutes?
Yes.
Thank you very much. Actually, I have addressed the lack of a timer here before. I thought that problem was going to be solved. You may remember that the president of the Library Commission was found after a referral by this body to be in below the standard of decency, good faith, and fair dealing by the Ethics Commission, and there was a letter going from the Ethics Commission to the mayor recommending her removal from office. That was on July 11th. On July 21st, one of the members of the Library Commission said, and I've transcribed this directly from the tape, you know, last Monday when we had met, the commissioners had met, we talked about how the changes to the printing system would impact staff as well. I was just wondering if it would be worth it to speak to the public about how it impacts the staff as well. Of course, the Library Commission meets on a Thursday. There was no public notice of a meeting the previous Monday. This commissioner is basically confessing to an illegal meeting of the Library Commission. Of course, I pointed out that his statement, which does not appear on the minutes of the Library Commission, not only that, but my reference to it at various subsequent Library Commissions also never appeared in the minutes of the Library Commission. Of course, I submit citizen summaries, and those citizen summaries are attached in an addendum, which are superfluous, well, they're an addendum. As I say, this was discussed several times. I think it sends the message that the Library Commission is saying, well, if you find our president in contempt of public decency and willful violating the Sunshine Ordinance, we're just going to ignore it completely. After I brought this up several times, finally at the December 15 meeting, that same commissioner said, there is just a thing in reference to an illegal meeting, which was simply a briefing. I just want to be sure that is clear. There's no such thing as an illegal meeting. It was purely a briefing. Well, you don't have to be too educated about the Sunshine Ordinance to know that a collective receiving of information is part of the meeting as much as the decision itself. So this is an example. I think the point is that when we come and make complaints, they try to perpetuate the myth that it's just some little technical thing that's out of character. And in fact, the entire situation is a categorical denial of due process, Sunshine Ordinance, openness, and everything else. Thank you very much.
Thank you.
Good evening, Chair Johnson and task force members. I'm Patrick Manetshaw. I do want to express my disappointment in the agenda for tonight's meeting, although I received a summary of it from the new task force administrator and then pointedly followed up to ask if there was going to be a detailed agenda. It was not emailed to the usual and customary Sunshine Task Force interested persons list. I only obtained today's agenda by having gone out onto the website and found it myself, which stands in stark contrast to the years and years and years that I've received the agendas via email. I ask that you reinstate that list and make sure that going forward, the full agenda with the timing of each agenda item's discussion and action be emailed to the interested parties. Because you are well past the 50 minutes allotted for items 1 through 6, and you still got public comment to go. I am not feeling well. Item on tonight's agenda is at item 15 and 16, And I would venture a guess you're not going to get to it until 9 or 9:30 or 10. So I would ask through the chair that you postpone my case until your next meeting, and then I'd like it earlier on the agenda if at all possible. Is that possible, Chair Johnson, for you to continue
Is
my
the-
case?
Can we take this up after the public comment is over?
I can say as long as public comment, but I'm really not feeling well.
Okay, just so that we can move on with the public comment, I'll come right back to it at the end of this item.
Thank you.
Hello, members. My name is William Clark. Last month, I had the privilege of giving you good news regarding the $18,000 management and supervision charges to the Street Arts program for 09-10. Well, this month, I have bad news to tell you. On Friday, the 27th at 3 o'clock, I received notice that a meeting was going to be held at the Executive Committee of the Arts Commission regarding the street arts budgets, proposed budgets for 12-13 and 13-14. On Monday at 3 o'clock, I attended that meeting, and on Friday I received copies of the proposed budgets for those 2 years, and in that copy there was also records of what the actual expenses were for the this year that we're in, and the 10-11 expenses. And in the expenses for 10-11, it was noted that $20,000 was spent for management and supervision charges and assessed against the street artist program. And this was a month after I got the information, and that apparently the acting director, a month after the controller notified the Arts Commission that the previous management and supervision charge was improper because there was no public hearings, was improper process. She went ahead and charged the street artists another $20,000. And at the same time, I was notified that although the 09-10 management supervision charge was put back into the Street Arts Fund, I was told that we were not going to be allowed to use that money at the beginning of the fiscal year that's coming up, and that money was going to be withheld from being counted as revenue at the beginning of the year for the upcoming fiscal year. So at the present time, we'll have over $60,000 surplus that's going to be withheld. And I also found out from Ms. J.D. Beltran at the executive committee, which was held just a few days ago, in that budget, in that 10-11 budget, I found out that $20,000 was charged to the Street Arts program for city attorney advice, and of that advice, $15,000 was for Sunshine Ordinance requests. And I asked for a detailed copy of what that was. And again, even though you found the city attorney in violation for not providing me with that information, they are refusing to give me that information for that particular year, any information explaining what those costs were. So I'll probably see you again in another complaint. And also, I was told by J.D. Beltran that the Art Commission sends every complaint, every request for a piece of paper over to the city attorney's office for him to redact any information from those documents. And I explained and that's why the expense is so high, because the Arts Commission is sending, whenever there's a request, they're sending they're sending that document, this is what they claim, over to the city attorney for him to go through every document and redact any information at a cost of $250 an hour to the Street Artists Program, when we hired a temporary person who's here tonight to help Mr. Lazar go through this. And he gets $25 an hour. But, and I explained that, I complained that I thought that they should, by this time, they should know what information needs to be redacted. So I just wanted to say, give you that information. Thank you.
Now that you've spent the better part of an hour talking about minutes, and I've expressed my views about the need for professionalism in the administrative office, I think there's something that needs to be said as well, which is the administrator's job is more than taking minutes. It's actually a pretty serious job because the administrator interfaces with the public in many ways and is supposed to provide information to the public regarding rights under the Sunshine Ordinance and the California public access laws. So the level of professionalism needs to be addressed, but obviously the task force can't do it. That can only come from the clerk. And since the clerk, who is an ex officio member of this body, has not shown up, at least in the last 4 years as I can recall, and her designee hasn't been here for almost as long, I think the real problem is that the clerk either has no interest in how well the administrator job and all the tasks associated with it is performed, or doesn't know how poorly it has been performed. I won't take a guess as to which it is, but I really think it's important that the task force remind the clerk, as the mayor, they are both ex officio members, so that when the agenda says that the ex officio offices are vacant, that's simply not true. They are filled, the mayor or his designee, and the clerk or her designee. But neither of them have seen fit to send anybody to the meetings. Thank you.
Peter Warfield, Library Users Association. I think you're hearing some very significant and very important issues from members of the public, and I'd certainly agree with everything that I've heard. I requested this morning information about complaints that Library Users Association had filed in 2011 or that had been dealt with, and also complaints that had been filed against the library or had been dealt with, filed by others. And eventually I got a complaints 2011, apparently a 2011 complaint log, which I had on my second or third call spoken to somebody at the front office would certainly do to satisfy a major portion of that request. Here's what it says about Library Users Association complaints against the Arts Commission. And I'll read it exactly as it appears on the log that I ultimately received. TF 1122 2011, comma, 1214 2011, comma, EOTC 214 2012. That's the entire entry. And the other one, TF 1122 2011, comma, 1128 2011, comma, 1214 2011, space, 214 2012. That's it. Am I to understand there's no indication of what the violation was, that there's no indication of what the complaint was about, there's no indication of what the subject was, there's no indication of what the law was that was violated that you found in your 9-0 votes on 1214? And am I to understand that on 214, the Education Outreach and Training Committee in one of these cases, and maybe in the other one, heard something which I had no idea was coming up? I don't know. I'd certainly like to ask. But what kind of a log is this? It's a disastrous come down from even the minimal log that you used to keep. Again, incomprehensible to certainly any ordinary person. The person who spoke first about library meetings, I attended those library commission meetings too, and yes, they minimized and trivialized their apparently secret meeting, even as they confirmed it. And it was an important one because certainly I had been making a very strong statement about problems. I also hope that you go into the city attorney's role in violating sunshine and in withholding documents. I hope that you in future will have a calendar of meetings and deadlines for agenda packets, which you haven't had yet, and certainly make the agendas and the minutes clearer as to what the underlying complaint is about and what actually was the concern of the person making the complaint. Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. And I'm going to coin a phrase. You can please some of the people some of the time, all of the people some of the time, but you can't please all of the people all of the time. And I know that there probably is a tendency at times to sit there and say, God, what do these people want? All they come is and say, you didn't do this, and you aren't doing that, and whatever. But I want to say that over the last year in particular, I have noticed a substantial movement forward, progress being made in standing up for the rights of the citizens of this city, both to make public comment at meetings and to acquire public records. And a lot of that, if not all of that, is due to a combination of the citizens bringing the complaints and this task force working with them to really do a discussion of those complaints and come to determinations which move open government in the right direction. So please, just from my perspective, as much as you hear, why aren't you doing this? Why aren't you doing that? Don't let that get to you. Focus at least on what I think is important, which is that most of what you're doing is moving in the right direction. And it is really moving the rights of the citizens of this city, again, to make public comment and to participate fully in the operations of government, whether it's to simply observe what's being done or to actually look at and put and have input into that system. And you are moving that forward. Now, if there's nothing else that will convince you of that, just look at the reactions you get from the Board of Supervisors and others when they're found in violation for the first time in 12 years since the 1999 revision of the law. And they're going, oh, what's going on here? What's going on here? Well, what's going on here is finally the citizens are waking up and they're saying, no, these aren't right. And they're going to a task force which listens to them and actually then provides them with an option other than going to court. And I think that is critically important because most citizens of this city can't afford to take the city to court. The city has 200 plus lawyers. They have unlimited resources, and they can obfuscate and delay and do everything they can to keep a citizen from doing anything, not to mention the enormous cost in both money and in emotional distress that necessitates taking somebody to court. And I think this body has done a lot to help move that forward. And with those decisions, even though the bodies in question still may choose to ignore them, the person who got the decision can go and say, well, somebody agrees with me. Somebody thinks what I was doing or saying was correct. And I can then go back to that body and say, well, what the lawyers call it is constructive notice. It's not just me saying what you're doing is not right. It's an official city body saying it's not right. And one of the things when you go to court, the judges will typically say is if you haven't exhausted local administrative remedies, go back and start from the beginning. This is a local administrative remedy, thank you. And it does provide the opportunity for members of the public to sometimes get something done without having to go to court, but in the absence of that, gives them the ammunition they need to go to court.
Thomas Piccirillo. Actually, I do spell my name with an H now. First name, I use an H. And let me apologize to Member Nee if I misheard or misinterpreted what he said regarding elaboration during public comment. Secondly, this business about ex officio officers not being present. I think it's required under the Sunshine Ordinance. So there's nothing to preclude you from not being proactive and doing something about it rather than waiting for somebody to file a complaint regarding the issue of the ex officio members not being here. If it's required by the Sunshine, you can do something proactively. Maybe write strong letters to both the mayor and the clerk, telling him where are your appointments. Thirdly, obviously this process is not working in the sense that people that file complaints should not have to wait till 10:30 at night to hear their complaints heard. They don't get on calendar for 2 to 3 months to start with. So if somebody wants a document, you're making them wait 2 to 3 months, and then you're making them wait until 11 o'clock at night to hear their complaint. You need to shorten up this whole process. Either that or meet twice a month. Your agenda's way too long, and then you're discouraging people from filing complaints by making them wait 3 months and then making them wait for 5 hours to hear their complaints. And then you take 3 months before you finally get a resolution or an order of determination. So the process is not working for members of the public that want documents or complaining about not having open meetings. Finally, agenda packets. You have one agenda packet for all the members of the public. Some of these members of the public don't have laptops, and so they can't go online and read the packet materials prior to the meetings. At a minimum, you should have 3 agenda full packets for the members of the public so that 16 people don't have to share one book at the same time. Thank you.
Is there any additional public comment for items not on the agenda? Okay, seeing none, public comment is closed. I know that we have a request for 11090 to be continued to the next meeting. Is the controller's office here? Hi.
Good evening. I'm Monique Smuda, Deputy Controller.
Do you have an objection to the item being continued to the next meeting?
No objection.
No. Okay. This, for the task force members, it's items 15 and 16. Is there a motion to continue those items to the next meeting? We'll try to put them as close to the beginning of the agenda. It's a little bit difficult on this. We'll see how far we get on this because of the timing of the 2 agendas being one right after the other, but we'll put it as close to the front of the agenda as possible. Hopefully, we'll get through these others in the front of it, and it'll be the first one there.
So move.
Is there a second? Okay. Is there a public comment on continuing this item? Okay, seeing none, then can we continue the item without objection? Okay, so then those complaint 11090 is continued to the March 7th meeting. Can you read the next item on the agenda?
Item number 7, discussion of survey of costs of compliance with City Sunshine Ordinance.
Are they coming back? Do you know if they're, Mr. Minette-Shaw, do you know if they're coming back? He doesn't know.
Number 8 called?
7.
Oh, 7.
We're on 7. This item was, I wasn't sure what agenda to put it on. Member Nee had requested it be on this agenda. I don't know if Member Nee would like to say something about it first.
Well, I have a number of comments regarding it.
Would you like to introduce what it is in case the other task force members, I'm familiar with what's going on, but I don't know that everybody else is.
Well, Supervisor Wiener asked the controller to conduct a survey of city departments, agencies, et cetera, on their costs for complying with the Sunshine Ordinance. And I think he was aiming specific attention at how much overtime is accrued by city personnel who have to attend our meetings as respondents to complaints. As I looked at the survey, there are a whole bunch of questions and comments that I have, but I'm not the only one who is aware of that this survey is going on. In short, I see what Mr. Wiener is doing, in spite of his denials, as an attempt to weaken the Sunshine Ordinance and to weaken, to emasculate this task force. And I think we need to look this over very thoroughly. We have the survey questions in our packet. We need to look them over very thoroughly, and I think we need to develop a very thorough and very reasoned response. Perhaps we should wait till after the data come forth from the survey, from the survey responses. But I think we need to be aware that this is happening, and we're gonna need to prepare to defend the ordinance and to defend what we do here. I'll leave it at that for the moment. Some of members of the task force may have their own comments and concerns about the survey. Members of the public might, and I'm certainly willing to wait to hear from others on it. I'll stop there.
There's a whole group of people that are interested in what is going on with the survey. I would like to say for the record that it was very difficult to find out information about the survey. Supervisor Wiener is allowed to make a request of the budget analyst to do an audit, and any member of the Board of Supervisors can do so confidentially. So there's no open government there, and they just approved that again in the same legislative analyst and budget plan. And I originally made the Sunshine request for the survey instrument itself, and someone else made the Sunshine request for who had requested it. And I got to tell you, he had to make two requests that were quite detailed and were unnecessarily getting the actual one-page document that Supervisor Wiener had made this request for a survey. When it was clear we were asking for who had ordered the survey, it took a couple of times to get it. When I called the budget and legislative analysts, I understand people being reluctant. What are you asking for? What kind of information do you want? I just wanted contact information. And it took quite a bit to get them to give me contact information. So our concern here is that Supervisor Wiener in the San Francisco Bay Guardian made some comments that were directed at the task force itself. So he is not opposed to the ordinance, but doesn't like the task force and thinks that it is ineffectively run. So there are a number of people who've been looking at this, a number of people who have an interest in it, and I know that they have been bringing up a lot of really important issues. Number one is that the survey, if you look at it, just some things to look at as we consider a response, is that it doesn't separate out the state laws or the federal laws like FOIA, but it doesn't separate out the California Public Records Act from the Sunshine Ordinance. So some of the requests would have to be responded to anyway. And then, of course, the task force itself is a a way to prevent the idea that people's only remedy is to go to court, which is very expensive. And the task force is one of the only entities that actually assists members of the public in getting enforcement. Otherwise, almost all the enforcement is internal. So those are some of our concerns. I do agree with Member Nee that it's a little bit difficult to respond, although if you do see things, there are a number of people who I know are discussing with the budget and legislative analysts concerns that they have directly with the survey itself. So if we do see things that we think are important, you can send an email to the budget and legislative analysts who's doing the audit and collecting up that information. I wanted to thank Chemo Crossman for sending some of us a link to a Seattle Times news article. When I say us, I don't mean the task force. I don't know if people from the task force got it, but there were a number of people that he had sent it to. And it's New Ideas Considered for Public Records Disputes, and it discusses that in Olympia, Washington, they're having a huge increase in payouts from public record disputes because they've been going to court. So that's one of the things the task force is trying to be here for, so people don't have to go to court. I also wanted to just point out that a lot of the times that when the cases come to us, they're about money that people want to document where the money is going. And every time somebody brings up money, suddenly there are no records, nobody knows what's going on, they have no idea where anything is. So when in front of the Library Commission came before us in one of our cases, and somebody wanted to know, how is this discretionary $65,000 spent? And suddenly there was no information. The same thing with the Muni drivers. They wanted some information about how that trust fund that's going to be eliminated will be paid out. And they were able to provide all the other documents, but nothing related to how the trust fund would be paid out. The same thing with the Arts Commission. Every time somebody wants to know information about the budget and where the money is going, they can't get that information. So that's something they can't really quantify in the costs. But there are a lot of other issues too. Member Name?
Just one other comment. The survey asks how much it costs to comply with the ordinance. Fact is, there is no mention in that survey anywhere of how much it costs not to comply with the ordinance. And the reason that this task force is here is that in many cases there is non-compliance with the ordinance, and it costs the city dearly.
Is there a public comment on the item?
Good evening again, task force members and Chair Johnson. I am part of the Sunshine Posse crowd that has been already starting to look at some of the preliminary responses coming back from the city departments. When I started reviewing them, I put in a public records request to Ms. Osbury, requesting the Sunshine Ordinance Task Force log for 2011 of every Sunshine case heard by this task force. I heard not one peep out of Ms. Osbury, did not receive an acknowledgement of my immediate disclosure request. I did not get a response from her. I did get a single email from her with the summary of tonight's agenda, not the specific agenda, with the timed minutes. But it's very odd that Mr. Rustin was replaced, and suddenly Ms. Osbury is not responding to immediate disclosure requests from this very body that's charged with making sure that city agencies respond to immediate disclosure requests. With that said, I think it is absolutely unethical for Mr. Supervisor Scott Wiener to have gone to Mr. Harvey Rose requesting some kind of an analysis of the costs without having had the common courtesy to advise the Sunshine Task Force itself about what he was up to. I'm encouraging folks up in Supervisor Wiener's district to mount a recall campaign against him for this very failure of not reaching out to the very body who is trying to avoid city costs and to lower city costs. Many of these cases could go to court, and as Mr. Alan Grossman's out-of-court settlement with the Ethics Commission proved, the city was left on the hook for paying $25,000 in legal fees. If Mr. Wiener wants to lower the cost of Sunshine, he should have come to you first in an effort to try to reduce litigation against the city. He must surely know, being a Harvard-trained lawyer, that many of the Sunshine cases here are required not only by CIPRA or federal law or the Sunshine Ordinance. They are mandated by the various missions of each city department, which varies widely. Whether there are actual laws that require the various city departments to provide records, they have an ethical responsibility to provide many of them simply because of their charters. That he went and asked Harvey Rose for an analysis of costs without considering the benefits of the ordinance and the good work that is done by this task force is absolutely reprehensible. And Mr. Wiener, who I'm having trouble addressing as supervisor, should be entirely ashamed of himself. And I hope he's listening tonight.
Thomas Piccirillo. First, I want to thank Member Neve for putting this on the agenda tonight. It's a very critical issue. And I agree that the intent of Supervisor Wiener is to weaken the Sunshine Ordinance as well as the task force. But I disagree with his conclusion that you should wait until the results are in. You already have the results of 37 or 38 of the 47 departments that have been surveyed. And you also have the survey itself. So there can be some responses now by the task force rather than wait until the final survey results are in. I think you need to intervene now. It would be helpful for you to respond with your comments to BLA as to why the problems with the survey and the problems with some of the responses. Task force members should also know that Supervisor Wiener was held in violation of the Sunshine Ordinance, if you recall. There was an order of determination against Supervisor Wiener. And this came, the survey idea came up shortly thereafter. So it's not a coincidence what Supervisor Wiener has in mind. But we all know that the Sunshine Ordinance is a charter amendment, and it can't be abolished or restricted by supervisors, so it'd have to go back to the voters. So we're lucky in that sense. But I do urge you to intervene now and not wait until the final results are in. Your input could be very helpful to the controller, the BLA office, when they do their report. Thank you.
Is there additional public comment?
Peter Warfield, Library Users Association. First of all, thank you for having the item on the agenda and for making the comments that were made. I think the task force comments, as well as the members of the public comments, are good to keep in mind. Part of the issue, I think, is that this is a task force now that seems to be willing to take on and to find in violation folks who are in positions of power. And sometimes when you do a good job, you generate opposition. If you were completely worthless and impotent, if you were idiots accomplishing nothing, people wouldn't be worried about what you're doing, nor, I think, would they really much be concerned. It's often when you're the most effective that some people are the most opposed. And I think this task force has, in many respects, been a good one. As somebody previously mentioned, I think it was Ray Hartz, you hear a good deal of complaint, but I would also agree with him that this is, and has been in recent times certainly, an improved and an effective task force, and I appreciate that. With respect to the material that's been going around, certainly I have been reticent to participate, but not reticent to speak to the Board of Supervisors. And I think if you will go to the SFGov TV recording of today's meeting, you will find that I and a number of other people, some of whom were here earlier but left, did speak in very strong terms publicly to the Board of Supervisors about this, what I called a setting the stage for a hatchet job against both the Sunshine Ordinance and those who would use it on behalf of public knowledge and awareness. I wish and hope that the excellent Alan Grossman will talk about his legal opinion about their claim to have a right to secrecy as to what they are requesting their legislative analysts do, and their reluctance to release information about it. I think that's outrageous and should not be tolerated by any of you, and certainly not the chair. I hope that a sunshine violation will be filed. So thank you for taking this up, and I do think sooner rather than later is the best time to head off what looks like a hatchet job against the public and against Sunshine. Thank you.
Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. First, I'd like to say that there were comments made both before the Board of Supervisors and here before the task force today where there was some confusion about the supervisor's name. And instead of saying Wiener, they said Weiner. And I think it was just a Freudian slip, so I'd ask you to, just, it's what they're thinking and comes out of their mouth. Weiner. Anyway, just because you can do something doesn't mean you should. And I'd let Mr. Grossman address more accurately whether or not they have the right to do one of these surveys and keep it hidden. I personally, and I'll say this is me, if I were a member of the Board of Supervisors and I wanted to go out and do a survey regarding somebody, I would not be afraid to let anybody who wanted to see it see it. And I think that's what Supervisor Wiener is. He is afraid to let somebody see it and doesn't want them to see that what he is getting from his survey is, I think, exactly what he wants. I served on the staff of Commander-in-Chief Pacific Fleet. My direct supervisor was an 06, a Navy captain, and reported directly to Commander-in-Chief Pacific Fleet, who is the person in charge of all military in the entire Western Hemisphere, all branches of the United States military, so forth. And we would do attitudinal surveys, and they sent me to a course at the Naval Postgraduate School in Monterey. And they taught us, you get what you ask for. When you formulate a question or you formulate a survey, the results you get are going to be pretty reflective of the way you ask the question. And if you want certain results, you can get those results by asking the questions in a certain way. And I think most of us have seen this in the political arena, where they do these surveys and ask people questions, and you say, well, I can see why people answered that way, but I don't think it was a very good question. Supervisor Wiener is also the supervisor who put on the agenda or a thing to allow the Board of Supervisors to change the laws in the city without having to go back to the people, including at first the voter-initiated referendums. And some of us went and talked about that, and he did this very, I'll be, we won't do the publicly initiated referendums. We'll only do stuff that the Board of Supervisors does. But the bottom line is it was defeated 2-1, because I think the citizens of this city realize that we need to be involved in government, and if we're not, then government is going to take off on its own in directions that we probably are not going to like and not even realize until it comes to hit us. I think the Park Merced deal, I think a lot of different things I've seen the city do where they deny public participation and ignore public comment is really something that many citizens are becoming aware of, and a lot of that has to do with your efforts. So keep track of this, and it isn't necessarily to respond to it right away, but I think we all know what Supervisor Wiener is trying to do with his survey.
Is there additional public comment? Okay, seeing none, public comment is closed. I hope it's okay to share this information. It's public information, but one of our concerns, I think tonight we're not going to be able to necessarily formulate a response, but we could put this back on the agenda for the 7th, and maybe people would have an opportunity to either send in some information to include in the packet, or at least digest what is going on for those of you that are just hearing about it for the first time. But just to give you an idea of how some of this plays out, the SFMTA, in their response, originally claimed something like 1,800 sunshine requests. When the members of the Sunshine Posse that are working on this chose to request supporting documentation, that number suddenly dropped to around 330. So it's pretty difficult for us to, it's estimates of things that are going on. There's some departments who combine their the classifications of city employees determine the pay range, and there's some of them that are combining those pay ranges, some of them are using the upper levels of pay ranges, even though that's not necessarily the employee who's responding. The Department of Elections didn't separate out all of its responses from things that it would have responded to anyway under campaign laws and under the California Public Records Act. So it had this enormous number, but that had no delineation of whether it was about the Sunshine Ordinance or not. Now, there are some things that are associated with our meetings, that some that are long-standing, like the way the complaints are handled. When Vice Chair Wolf and I met with the clerk's office, we had offered up some ideas about making the complaints a little more streamlined, working with the clerk's office to have the administrator go back a little bit in time and do some work with the complainant and the respondent to get some of the things resolved. We'll see how that goes. So those are some of the things that you might want to take into consideration as you consider how we might respond. I don't know if it's a good idea or not to respond beforehand. I do think it's a good idea to respond in some way. But I also don't necessarily want to come across as trying to eliminate the idea of the numbers. I'm not afraid of the numbers. I think what the task force does is really important. That's why we spend a lot of hours doing it. I think a lot of the departments get upset when they feel like they're sharing information that belongs to them, and I think the task force reminds them that that information belongs to the people of San Francisco. And so those are the kinds of things we might want to take into consideration. So what do you think about putting it on the next agenda for people to consider?
I would definitely be in
Costa?
favor of that idea. I would like to echo everything that Chair Johnson and Member Nee have said. I'm definitely on board with that idea.
Member Nee?
I agree too.
Yep, okay.
Madam Chair, what I might suggest is that each of us, between now and then, submit through our clerk a list of questions and comments to be considered at that meeting. In other words, we're not. My suggestion is that each of us, between now and then, submit through our clerk a list of particular questions and concerns that each of us has regarding the survey itself, the questions thereon. I think some of those questions are patently absurd or vague. And then also, as we see the responses to the survey, we might want to comment on those also. Again, submitting those comments through the clerk.
Member Costa?
I think that seems sensible. I also think it seems important, and I don't even really know exactly how to address this other than just keeping it in mind, but how one would separate out costs that really implicate the task force in any sort of way, as opposed to just the ordinance as a whole. You know, these complaints can be submitted and are being, or requests, I guess, for documents are being submitted. Is it just about complaints, or is it about requests for documents overall and dealing with public records requests? Because some of that doesn't directly involve the task force.
If you look at the survey, it does have both of those things in there, sunshine ordinance related tasks. I mean, I agree with Member Nee that some of them are vague. Another thing that's interesting is that the sunshine ordinance actually says that the work of responding to records requests is part of their job. So there is no cost associated with that. So the problem is that the comments that Supervisor Wiener made to the media and the survey itself lends itself towards the idea that the task force is creating a lot of, that it's the task force that is the problem. Mm-hmm. Since I haven't personally spoken to him or anything like that, I'm not trying to speak for him. That's what I read, and you can read some of it and see that it talks about how many hearings you've had to attend. And it's a little bit difficult because like the SFMTA responded that they had to attend 58 hearings in 2011, but I counted them and there was nowhere near 58. And it turns out that they had reported for 2011 the numbers for 2010, 2011, and 2012. So if we had not received information about this, we would have seen these numbers and had to be, racing to catch up. But as it is, we're lucky and we have people who really care about the Sunshine Ordinance and the open government, and the people who have learned how to assert their rights under that are sometimes villainized. They're sometimes considered, they're called annoyances or the equivalent of vexatious litigants. But the reality is they've learned how to assert their rights under the law that's for the public. And they sometimes are able to spot things the same way that an attorney goes into court and spots things that other people who don't have that experience can see. So the survey seems to be leaning in a biased way towards aiming at a specific goal of making it look like there are just a handful of people on the task force that are creating a problem or spending a lot of money. I will also remind the task force and the members of the public that we're one of the only entities that helps the public that we have no staff. So the Ethics Commission has a number of attorneys that work for it. It has an executive director. They have a budget, their own budget, and it's way bigger than our budget. So part of what happens is that we don't have necessarily an advocate the way that Mr. St. Croix is an advocate for the Ethics Commission that's paid by the city. Those are costs that I think need to be considered as well. No, we were just suggesting that we put it to the 7th, and there was no motion, but Member Snyder.
I just wanted to add one point, or more precisely elaborate on a point that somebody else made, which is a point that should be made in response to the evident efforts of Supervisor Wiener to undercut what the task force does. And the point is this, and I'll try to make it as brief as possible. One of the functions of the task force is to repair bad practices in the city with respect to openness of government. By being forced to come before this body, the heads of agencies are required to account for their practices, and that in turn causes them to go back to their agencies and repair, as I said before, bad practices. And we see that again and again. We see the gentleman from the MTA, whose name I don't remember, told us again and again, we have revised our policies because of what we've learned here at the task force. So think of it maybe as training, sort of sunshine training on steroids. The upshot of that is that it saves the city money in a way that may be hard to quantify, because it reduces the likelihood, and maybe significantly, it reduces the risk that the city is exposed to from litigation over violations of the California Public Records Act, the Sunshine Ordinance. Federal wouldn't apply, but state and local laws. If the MTA has improved its policies as a result of coming before us, or at least partly as a result of coming before us, the likelihood that they're going to face a lawsuit over bad sunshine practices drops substantially. This is it's an argument that's important to make, but it's an argument that is hard to back up, because you're trying to prove a negative. It saved the city money. Well, how do you show that somebody decided not to file a lawsuit? You can't. But if Supervisor Wiener's effort is to show, look how much this is costing the city, an important message for us to get out in return is there are huge invisible savings that go on because of the education that this body provides in the form of its enforcement activities and in the form of its formal education activities.
So we'll have the task force members send, not to each other, but to the administrator for the packet for the next meeting on March 7th, their ideas, so that we could have a more informed discussion about what kind of a response. I'm going to say that one of the things that is my favorite thing about this is that in the public comment and in people writing and in comments on even SF Gate, where people are really nasty, people cannot bring themselves to call him Wiener. Everybody spells it W-E-I-N-E-R. It's Wiener, W-I-E-N-E-R. And he pronounces it Wiener. I worked with him at Heller Urban a long time ago. So it's very funny that people are just so reluctant to use it as that name. We're not making a motion, we're just moving it to, we don't need a motion to continue it, do we? DC 3, or do we? Okay. We're going to, is there a motion to continue it to the March 7th meeting?
So moved.
Second.
So, since it's late, we're not going to have public comment on it because it's a procedural motion. We already took public comment on that.
I've never heard of a procedural motion that doesn't take public comment in a public
Have you ever been to a
meeting.
Board of Supervisors meeting?
They have different rules than you do, Chair Johnson.
We're not taking public comment on it. We're just continuing it. I'm sorry. We already have public comment on the item itself. So it's there. Can we do it without objection? Okay, so we're moving it to the March 7th. We're continuing to the March 7th.
Madam Chair, could I request a 5-minute recess?
Yes, we'll take a 5-minute recess.
Use PowerPoints for the. Okay. Well, do we need to bring anything? No, if you guys. Do you know who else is speaking on that panel yet?
So I do, and is someone from the Bay Citizen?
That's fine. I have no problem with the Bay Citizens. That's great. Who is
Okay.
it?
Okay, we're back from recess. And we're temporarily going to have Mr. Is it Young? One thing, we're going to go on to item number 8 just before we address jurisdiction because I need Andrea to come back to tell me if Mr. Pitt's document is available. So we're going to item 8.
Item number 8. The Compliance and Amendment Committee has referred 11056 Alan Grossman versus Dennis Herrera and Jack Song of the City Attorney's Office back to the task force with a recommendation that it be referred to the Ethics Commission with a request for enforcement of the order of determination and to find Mr. Song in violation of Section 67.21E for being absent during the latter part of the committee's hearing on the item.
So the complainant will have 5 minutes.
What?
I'm sorry, Member Chan?
Well, I make a disclosure that I do know Mr. Song, and it does not, compare.
It's not a problem. At the last Compliance and Amendments Committee meeting, Mr. Song continued to insist there were no records of any kind that related to the 3 letters from the city attorney to the task force, or for that matter, to any of the other 148 general fund departments that notified them of reductions in hours of their assigned deputy city attorneys. Mr. Song left before the hearing on the complaint ended. So what we have is the city attorney's official position that there are no records in existence in his office that show who prepared the 3 annual letters, what data was used, who made the calculations, who reviewed them, or who sent them to the task force. I personally believe that Mr. Song was told whomever he asked exactly that. But since he was not personally involved in the process and may not have asked the persons who were actually involved, we can't be completely sure of the answer. My case, my view is that if this case were referred to the Ethics Commission, it would not get very far. As the same answer would be given by Mr. Song or someone else in his office, no records. Mr. St. Croix hears that, no records, no enforcement. As for Mr. Song's early departures from the committee hearings, Mr. St. Croix would remind the task force that Section 6721E does not apply to respondent attendance at committee meetings. So it's a waste of everybody's time to send this case to ethics. Through my several records requests, the one relevant record I did receive was a copy of an email from Scott Minty to Marisa Murray dated in December 2011. That email, unfortunately, was omitted from your packet. That email disclosed that 3 persons in the city attorney's office might have had some hand in the preparation of these letters: Scott Minty, Marisa Murray, and Susanna Martinez, who are the IS Administrator Supervisor, Managing Attorney, and CFO, respectively, in the City Attorney's Office. Since they should have some firsthand knowledge, I submitted a record request to each for records in their personal custody that related to the preparation of the letters. None of the 3 individuals responded to my requests. I did receive a somewhat nasty letter from Mr. Song that my request for records regarding the general fund budgets that resulted in reduced hours for the task force would no longer be responded to. That letter, too, was omitted from your packet. Last month, on the 18th, I filed a complaint against each of the 3 named individuals for failing to respond to the request. Those complaints are pending. I might add that from what I understand, there are no answers been filed by any of them. Hopefully, those complaints would be heard next month. So at this point, I see the situation as follows. Over a period of months, through records requests and letters of Mr. Song, we now know that 3 persons in the city attorney's office could have knowledge of what happened or didn't happen. 2, logically, there should be some other emails in response to the one Mr. Song provided, even if the one he provided was not an original. 3, there's no point in pursuing this complaint any further. By that I mean, it's not going to go anywhere here because you can't do any more, and it's not going to go anywhere before the Ethics Commission because we know what's going to happen. So rather than waste your time and mine, I think that we should wait until we have a chance to hear from the 3 individuals who may be able to tell us more about what happened and who generated those letters. Of course, that's your decision. Thank you.
Thank you. Is there anybody to present facts and evidence in support of the complainant? Okay, seeing none, the respondent will have 5 minutes.
Good evening. My name is Jack Song, here to represent the City Attorney's Office. I want to reserve my time for my presentation for step 4 of the hearing during a rebuttal between the respondent and the complainant. Thank you.
Is there anybody to present facts and evidence in support of respondent? Seeing none, the matter is with the task force. I have one question, Mr. Grossman. The emails that everyone received the emails that you requested that Ms. Osbury send to us. Were those provided to you by Mr. Song?
The one email that I got from Mr. Song was in the packet for the Compliance and Amendments Committee meeting last month.
And then what about these 2 emails that we got tonight?
Okay, well, one of them is the one that involves the 3 individuals I mentioned. And if you note on the right-hand side, there's a date on it, December 28, I think, 2011. And I knew that couldn't be right because I put my request in before that date. So I asked Mr. Song to send me the original because this one looked like it was not an original. He told me it was the original. So I included a copy of another email from the exchange between people in the city attorney's office to demonstrate that the two were totally different, so that the one that I got that had the names of the three individuals was probably from an archive or some other place where it had been stored, rather than from an active account. And I, of course, am interested in the responses to that email, because Mr. Minty is saying, what are we going to do? Are we going to do the same thing again this year? And I'd like to find out what the other two people had to say about it.
So both of those you got from Mr. Song? Both of these emails?
No, the second one I got from another file.
Another file.
That was actually a case here, I think Mr. Clark's case.
Okay. Member Snyder?
Mr. Grossman? So, just procedurally, what do you think what do you want us to do here? Should we just let this matter conclude and not take it any further? Is that what you're asking with this complaint?
Well, it's really up to you, because we don't have anything. We've got that one email is all I ever got. You know, I did get some background information on the three individuals, but that's not, I could have gotten that elsewhere. I didn't need to make a request for that from Mr. Song. The point is that something happened in 2007, 2008, 2009, and 2010. The city attorney said, we've reviewed our records. Because of budgetary constraints, we've got to reduce your hours. And we've calculated what we think is right. And they came up with 348 hours or something like that. And they did the same in each of the two following years. My question is, show me the calculations. That's all I wanted to see. They have no paper trail, none whatsoever, according to Mr. Song.
But as far as this complaint,
but this complaint,
should
I would just say, listen, we're not going to get anything more from this complaint, because Mr. Song has given us everything he can give us. But he may not have given us what other people have that they don't want to provide him, or they may not have even asked about it.
So you're asking us to not refer this to ethics?
Pardon?
Are you asking us to not refer this to ethics?
Well, you can, but you're just going to get a dismissal letter, and you'll do some work on a referral letter, and the administrator is going to have to put together. It's a waste of time, in my view.
Okay, if there's no further discussion with by the task force, we can do the rebuttal remarks. So then that would be the respondent and then the complainant. So you'll each have 3 minutes.
Thank you. I would like for this case to go to the Ethics Commission for review. I have spent, starting June 2011, this was the beginning of this case with Mr. Grossman. And actually, I want to backtrack a little bit. The survey that the task force was discussing earlier, it was actually a really good exercise for me personally, because what I realized was how much time that I spent particularly with Mr. Alan Grossman's request. And it turns out that the requests that we get from the general public, not from Mr. Grossman, but from the general public, it's actually not as time consuming. The time and cost spent on this particular matter is an example of the waste that goes into complying with unreasonable requests. And it's really not honoring the spirit of the Sunshine Ordinance. This request came back in June of 2011. Mr. Grossman was asking for the baseline budget from 8 years ago. We said we do not have that, but we understand where he was coming from. He was afraid that the Sunshine Ordinance Task Force, the budget was being cut, and service is being impacted. We said, and he was concerned that there is a trend, that it's the hours provided to the task force has been cut over the years. What we did was we it's not required to produce the document, but what we did, we produced a Excel sheet for Mr. Grossman, listing the hours all the way dating back to 1991, and you see the fluctuation. And yes, there is a budget situation with the city overall. Mr. Grossman asked, why is there a budget cut? The mayor asked all general fund departments for a 10% cut. That went across board. We explained that to Mr. Grossman in writing. There's been a total of about 20 correspondence dating back from June 2011 up till this point. We provided all the responsive documents that we can up to this point, including documents that we created to let Mr. Grossman better understand the budget, how our office deal with the budget and allow hours. We also emphasized to Mr. Grossman that the task force here can discuss additional hours needs with our deputy city attorneys. That same information and message was the same to all general fund departments. And I just want to end with, why did I leave early at the last committee meeting? I was quite offended by one of the task force members' gesture and treatment really toward me as a public information officer. Mr. Grossman made an inaccurate remark. He wanted to know, actually, it was a misunderstanding. He did not know. He did not know, but it was an inaccurate, I'm sorry, this will be my concluding remark. He was concerned that there's discrepancy between the budget that we provided to him and the total budget that the city attorney's office has. He said there's a point, I think he said there was $4 million missing. Where is that money going to? He made the remark, and I asked for permission to make some clarification, and I was rejected by one of the members of the task force. So for today, for the record, I would like to educate and let Mr. Grossman know that I believe the dollar amount was $4 million, the discrepancy. That dollar amount, what we get from our affirmative litigation cases, all that money goes directly back to affirmative lit. We can only do affirmative litigation. We cannot use that money that we get from the lawsuit, the settlement that we get from affirmative litigation cases to use on other things. So I just want to make that clarification. That's why I believe the discrepancy was not accounted for the general fund. So thank you.
Thank you. The complainant will now have 3 minutes for rebuttal.
Well, I suppose if Mr. Song wants us to go to ethics, it's because he wants to have ethics do what I predict they will do. So he must have some knowledge that makes him feel even better about it. The whole notion that I have refused to accept his oral explanations about how they went about doing this is an acceptable substitute for seeing it in a public record, which is referred to by his boss. You know, I just don't get it. As far as his time at the meetings, I think we're all here. He's actually paid, and we're not. I do want to say one other thing. It's pretty clear to me that there's a lack of knowledge about the public records laws in almost every department, and I will give you an example in this very case. According to Mr. Song, his office received more than 12 immediate disclosure requests from me in the past 6 months. 12 IDRs. Actually, what I did in the past 6 months was send 6 records requests because of his dribbling out information that ultimately got me that one email, which was not even an original. And only 2 of the 6 were IDRs because we had meetings coming up. And the other 6 were letters. They weren't demands of any kind. I wanted information. I needed clarification. So the fact is that He doesn't even understand the difference between an immediate disclosure request, a regular records request, and a letter requiring clarification. So, given the fact that he works in an office and his immediate boss is Matt Dorsey, who considers the task force a rogue organization, it doesn't surprise me that any information coming out of that office has to be done bit by bit rather than getting it all at once. Thank you.
Thank you. The matter is back with the task force. Member Snyder?
I think the only question we have in front of us now is whether to refer it to ethics. And given that the complainant himself doesn't want it referred to ethics, I don't think there's any reason that I don't think there's any independent duty that we do so. I'd be inclined to just let the matter conclude. We've found a violation. We've issued an order of determination. Complainant says, I don't want it to go to ethics. Why send it to ethics?
Yeah, the recommendation on the agenda is to send it to ethics for enforcement of the order. So if the complainant is not confident that ethics will enforce the order, I'm never sure that that's exactly the right thing to not send it over, because I think that persistence, as evidenced by William and Robert Clark, can pay off, that they're waiting for you to sort of give up. Member Costa?
Yeah, sort of along those lines, I mean, is there ever really confidence that ethics is going to enforce an order? It seems like more often than not there isn't. And so I guess the one thing that makes this case different is that the complainant is actually saying that and expressing no desire to have it forwarded. But I don't know if we want to really establish the precedent of not forwarding something just because we're not confident that ethics will enforce it. If that were going to be the case.
No, my basis would be that the complainant doesn't want it. It's almost like it's not really analogous, but it's something sort of like an appeal. You know, he's saying, I'm done. And as the complainant, he has the right to stop. He has the right to dismiss the action. He has the right to, I mean, it's not completely analogous, but it's kind of his ship to steer.
Okay. Member Nee?
I agree with Member Snyder. With this additional observation, it's not up to us to second guess what ethics might do in one case or another. And if Mr. Grossman or any other complainant wanted us at this stage to pursue the matter with ethics, I would say let's go ahead with it. But in this case, I will agree with Member Snyder that since the complainant does not want us to take the matter to ethics, I would say let's let it conclude.
Okay. One thing that I would just like to address is that it is a concern that there's no way to review how the budget process is created. And so the letter to Mr. Grossman on January 5th from the city attorney's office saying that there's a number of things. Number one, the idea that you would come in and discuss budget documents for an attorney's office to suggest that an oral communication would be adequate for something as controversial as the budget is not common practice for attorneys. I mean, they tend to pass things back and forth in writing between when something's adversarial or controversial. We've had other departments have complainants say they want complainant to come in, and I think complainants, members of the public and the Board of Supervisors, they have a right to have things in writing so that they can be documented and shown that something happened. A meeting is, unless you're going to record it, it's not something that you can have in your hand to demonstrate actions. So I think it is, I don't understand how the city attorney's office demonstrates its need for a specific budget without documents or some kind of information. I know we've gone through this, but I'm just addressing the idea that, you know, that Mr. Grossman's request are preventing 800,000 other people from getting the city attorney's office. I bet that Dennis Herrera trying to be in on taking his case to fight up to the Supreme Court for the recent Cobra case spent a lot of money and resources too, but it was something he felt that he needed to do, and maybe it was something he needed to do, and budget is really important, and to have things coming up in front of us continually that are just take my word for it is really difficult. And on that note, I agree with Member Snyder that the complainants were here because the complainants had a complaint, and if this is something that the complainant doesn't want to pursue, I agree with your reasoning. So is there a motion to... Do we need a motion to that effect, or can we just conclude it? Okay. Is there any further discussion? We've got to take public comment too. Is there any... Okay, is there public comment on this item?
Yes, Thomas Piccarello. You know, the violation of your order of determination found that the city attorney did violate the Sunshine Ordinance. And it is also true that Mr. Grossman was the complainant, but the violations that you found also run to the general public and not solely Mr. Grossman. I mean, it's very sad that Mr. Grossman has no confidence in the Ethics Commission to enforce your orders of determination. But what you should keep in mind is that the violation affects the general public in addition to Mr. Grossman. So you're making an error in not pursuing the matter to the Ethics Commission, despite Mr. Grossman having no confidence in the Ethics Commission. Secondly, there was an independent violation by Mr. Song when he left the proceedings. His leaving the proceedings was sort of, the analogy would be contempt of court. The violation was directed towards you and not Mr. Grossman, and him leaving the hearing. So even if Mr. Grossman doesn't want to pursue his order of determination on his specific violations, you should not let Mr. Song off the hook for leaving these proceedings, because that violation goes to the task force. It's contemptible. And at a minimum, you should take that issue up to the Ethics Commission. Thank you.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I can understand Mr. Grossman's hesitancy to send it over to ethics, because really what happens in effect is ethics simply disposes of it. I'm not going to call it a dismissal because it's not a disposal. And then what happens is the city attorney's office goes, aha, we were vindicated. Sunshine Task Force was wrong. Ethics Commission says so. We win. And as a result, what seems to be something that goes to the Ethics Commission and is honestly considered is simply something that is not honestly considered, and then it is used as fodder to say, oh, look at this guy, he filed this complaint, and ethics says we were in the right. The whole idea, and this went back to the original case, that in a budget process, somebody would say, well, our pluses and minuses are all based on a base budget, but we don't have the base budget. Well, how in the hell do you do calculations regarding city funds without a budget when you say that's part of your calculation? Just pull it out of your you-know-where And I think just idiotic. It's insulting to everyone's intelligence that someone would actually say, we don't have that, when they know they had to have had it at some point, or else they couldn't have done the calculations. The start of Mr. Song's comments here were, I think, insulting to the task force and to members of the public. Oh, look at this waste of money and resources that goes into compliance, and Mr. Grossman, yada, yada, yada. Whenever they can't refute the facts, they attack the personality. They go off on some tangent saying, oh, this horrible person abusing the law and taking advantage and whatever, as if one of us really has nothing better to do with our time and wouldn't be rather at home watching a movie than going through this process to get the government to do its damn job. And I'd say to Mr. Song, if you are saying that leaving because you can't have your way about everything is the way you handle your job, then you can't do your job and you ought to resign. And if you don't like the way people talk, if you can't stand the heat, get out of the kitchen. I told Mr. Dorsey this at one point. I said, would you please pass along to Mr. Song that I would appreciate it in cases involving me if they would stick to the facts of the case and stop attacking my personality. It seems like that was not passed along to him. This process is a frustrating one, and the conversations you're going to have with the Ethics Committee coming up are going to have to direct some of these issues, because bottom line is I can see Mr. Grossman's concern about having it sent to ethics, only to have the ethics dispose of it without a hearing and without any open public view of those process, and then have the city attorney go, aha, we're off the hook.
Peter Warfield, Library Users Association. I am wearing a coat and a scarf and a sweater and a wool jacket and a shirt because it's rather chilly in here, as I can tell from other folks on the task force and in the room. I hope that perhaps you can warm it up. The departure of Mr. Song, because, as he puts it, he was offended, well, he wasn't allowed to answer a question. He didn't get special treatment. He had had his turn, and now he wasn't given special treatment to be allowed to answer a question that had come up after he had his turn. You know, that's too bad. The idea that that would offend him, and coming from the city attorney's office, who has smeared in the ugliest possible way in the past in all kinds of ways, all kinds of folks who have had legitimate requests for information and so on and so forth and have come here, I think that's outrageous. I certainly wouldn't want to counter Mr. Grossman's request if he feels that this would be a waste of time to forward to the Ethics Commission. But there are two things that I think you haven't considered, and in one of them, I am sorry to say I have to disagree with Mr. Grossman. Section 6721E, as in Edward, has the last sentence reading as follows. An authorized representative of the custodian of the public records requested shall attend any hearing and explain the basis for its decision to withhold the records requested. I do not see there in the phrase any hearing, I do not see that this is restricted only to the full task force meetings and does not apply to subcommittee meetings. And I think that your 67.21E violation should, under that interpretation that I'm providing, stand and get acted upon appropriately, particularly because the city attorney ought to be a model of right and proper action. With respect to the chair's quite right question, how did they do this calculation? Well, maybe they had an idiot savant there. These are people who are able to focus tremendously on one subject, like multiplying seven-figure number by another seven-figure number, and boom, come up with the answer. They don't know anything else. I doubt it. Section 67.297, which you have not yet mentioned, says in portion A, the mayor and all department heads shall maintain and preserve in a professional and businesslike manner all documents and correspondence, including but not limited to letters, emails, drafts, memorandum, invoices, reports, and proposals, and shall disclose all such records in accordance with this ordinance. If they didn't have those records kept, maybe they're not keeping in a professional and businesslike manner all documents and correspondence that they should. Thank you.
Is there additional public comment on the item?
Yeah, I just think that under certain cases, the victim of a crime, they don't have the right to say that the government could or could not prosecute the perpetrator, like consider a domestic abuse case. You know, they move in and the domestic abuse victim, they can't back out. They can't say, oh, he didn't abuse me after the evidence. So I don't think he really has the right to dismiss this case like this and just sweep it under the rug.
Is there additional public comment? Okay, seeing none, public comment is closed. Member Costa?
Could I ask Mr. Grossman a question really quickly? Could you just clarify, is it that it's your desire not for this not to be forwarded on, or you at this point are just frustrated with the process to the point that you feel like you don't have confidence anything will come of it?
I think it's a little of that. I've dealt with St. Croix and the Ethics Commission about as much, I think, as anybody here, and I've read I think every one of the dismissal letters and a lot of other of the work that they have done in order to dismiss every records case they've ever had. And I can assure you that they will find a reason to dismiss this one, the one I just gave you, which is you can't enforce an order to produce records if they don't exist. I'm sure of that. On the second point, Mr. Song's failure to stay through the meetings before the Compliance Committee, they've already ruled in, I forgot which case it was, that Section 6721E does not apply to hearings before committees of the task force. So that would likely be. Now, the one thing you have to keep in mind about Mr. St. Croix and his staff is that they're incredibly creative about theories on which to dismiss cases, because they don't need an opinion from an attorney. They certainly don't need the city attorney's opinion. All they need is to put forth a reason in a report that goes to the commission. And with Mr. St. Croix's recommendation that there's no probable cause to have a hearing on this. If within 5 days from the time that the commissioners received that, less than 2 ask for a hearing, namely 0 or 1, there's no hearing. In other words, 2 or more have to ask for a hearing. So they have 5 days to try to figure out what's in this report, and you don't even know that he's actually put forth all of the facts and information that should be in the report, because he controls both the facts and the legal content of the report. So that's why, of the 39 cases or so, everyone's been dismissed. So I don't see that this case should go into that meat grinder, and put everybody here to have to do a little bit more work. David will have to write up the order of determination, or I guess the administrator, and then people have to review it, then it goes over there with all of the other material. I have 3 other cases that are going to be heard with people who should know. People who should know. The CFO, the managing attorney, and the guy who wrote it, Mr. Minty, who said, what are we going to do this year? And if they come in, which I'm not sure they will, because Mr. Song is already on record that we don't respond to those requests anymore because you keep asking for the same information. And we're not going to waste any more time with your cases. If they do show up, then we'll have a chance to find out. If they don't show up, then I think then we'll have a better case to go to ethics.
Thanks.
I draft the orders of determination. I spent a lot of time doing it, just letting you know. And then they review it, and I'm so grateful for them to review it because I can't put it in the legalese like that. But I spent a lot of time doing it. Member Costa.
I feel uncomfortable about not forwarding this on to ethics, to be totally honest with you. I completely hear where Mr. Grossman is coming from, but to me it doesn't sound like what he's saying is that he has a desire emerging from within himself to not want to continue on with this case. It seems like he's saying he's discouraged and he feels like it's not going to go anywhere, and so he feels like it is the least promising of several cases that he has to amount to anything. But I think that's a very dangerous precedent for us to set. I think that's, it's very kind and considerate of him to be concerned about how the task force is using its resources. But at the end of the day, it's the responsibility and the duty of the task force to be forwarding things like this onto the Ethics Commission. And in reality, they probably aren't going to do anything with it. However, it's going to be one more documentation of something, a decision we've made where we've found a violation that we have sent on to them, and then they've failed to do anything with it. I think, that is our job. Our job is to carry it through as far as we can. And I think that, to not do that here would be a disservice to Mr. Grossman for having taken it this far and bringing it before us.
Member Snyder?
Mr. Grossman also expressed a strategic basis for not forwarding this on to Ethics Commission. And if I understood what he said correctly, he thinks that his complaints coming forward after this one are going to be more effective and be a kind of tighter case to send on to the Ethics Commission. So just to put that in there, I think Mr. Grossman expressed more than just a frustration as a reason, but he expressed a strategic basis for it. And that's not reason for us to not forward it on necessarily, but it's just adds to the picture.
I do, based on what Member Snyder just said, I do think that one of the problems we have with this case is that there's not necessarily a piece of evidence that says, we keep saying we think there should be documents, but we're not having something in our hands that says there actually are additional documents. So if you want to refer to the Ethics Commission, Mr. Song, because on the agenda it says for leaving the meeting. I wasn't at that compliance and amendments meeting when that occurred, but you could do that. But I think we need to make the decision now instead of discussing what ethics will do with it. I think we've done this before with a different makeup of the task force, and every time people agreed in the long run that our decisions can't be based on their lack of actions. So we have to do what we think is right. So if someone wants to make a motion to send it over there, otherwise we need to move on to the remainder of the agenda.
I move that we forward it to ethics.
Second.
Do we have to take public comment on the motion? That's the first motion, right? Okay. Is there any discussion? What is it that what exactly are you very specifically, what are you referring to ethics? For enforcement of the order, for leaving the meeting? Can you be very specific?
Sorry, actually, I would like to make a motion that we forward it for both, for enforcement of the order and for Mr. Song leaving the meeting, which would be 6721E. Is that right? 21E. 6721E.
And on what basis do you want to? Well, I guess it doesn't really matter. We don't say that. We say that in the order of determination. Okay, is there any discussion of that motion among the task force? Is there any public comment on the motion?
Send it to ethics. Make Mr. St. Croix do his damn job.
Mr. Grossman has told me that he has changed his mind, so I think that means he supports the motion, and certainly, as my comments indicated, I do.
Yeah, I mean, if the motion is to send your order of determination on to the Ethics Commission, I'm in full agreement with it. And I thank you for raising the motion. If you think logically of what Mr. Grossman is asserting, then none of us would file complaints, right? Because we know ethics is not doing anything with the orders of determination. So the logic of Mr. Grossman is not beneficial for individuals seeking public records or attending open meetings. Thank you.
Okay, so no further public comment. Public comment is closed. Member Snyder.
Mr. Grossman, can I ask you one question? Sorry, one more time. Have you changed your mind? Do you want this to go to ethics?
I think I have, in a way, because I was focusing only on what was good for, I thought, for what I wanted to get out of it. But I think there is a broader, the broader issues actually are important. And it's not just about me, in other words. Thank you.
Okay, can you call the roll on the motion to forward the item to ethics for order to enforce the order of determination and for leaving the compliance and amendments meeting early?
On item number 8, Member Snyder.
Yes.
Member Nee.
Aye.
Member Monet.
Aye.
Member Costa.
Aye.
Member Chan. Aye. Member West.
Aye.
Chair Johnson.
Yes.
There are 7 ayes.
Okay, I have one question for you. So that's sent to Ethics and Commission. Ethics Commission. Ms. Osbury, did we receive from Mr. Pitts information that documents a portion of a contract for? Is that in here?
Yes.
I was going to entertain having the jurisdiction hearing early, but now that we have this document, it's a hearing that would take a little bit of time and I think cut into some of the other cases, so it wouldn't quite be fair to take it ahead of time because it's going to be probably longer than I had intended. Mr. Pitts, we do have your information.
If you can connect the internet, I received an additional document from Pamela Tebow regarding the issue. And
Okay, we can't discuss it right now, but we can turn that on for you.
Yeah, what I'm saying is if you turn it on, then I can look it up and then actually just produce it over here.
Okay, can we work on getting that set up? We have some time, it's not the next item. And can we read the next item on the agenda?
Item number 9, reconsideration of file number 11008, complaint filed by William Clark against the Arts Commission regarding incomplete audio cassette tapes of the January 12, 2011 Street Artist Program Committee meeting.
Okay.
For enforcement, yeah.
Okay,
Okay,
William.
so you'll have 5 minutes.
Okay, William Clark. First of all, I don't see Mr. Lazar present at the meeting, and I would like to remind the task force at the last month's meeting, you told Mr. Matos that you would no longer accept his representation in this case for the Arts Commission, and you instructed him to tell Mr. Lazar that he needed to be here personally to respond in this case, and that you would no longer accept any testimony from Mr. Matos as a representative of the Arts Commission in this case. And but that being said, I would like to give you a copy of emails that were sent to me by Mr. Lazar back in March 1st, 2011, in which he informs me that the Arts Commission no longer has the ability to make audio cassette copies, and that the Arts Commission can only make digital copies. And on February 2nd, I asked for an audio copy of the Executive Committee's meeting of January 30th, and I received that on February 7th, and I received an audio cassette copy. So this whole case is based on Mr. Lazar's statements that the tape that you have is the original tape, because the Arts Commission no longer has the ability to create audio cassette copies, yet just a few weeks ago I received an audio cassette copy of a meeting. And that's why I would like this email to be included in the information. Now, I've requested that you add additional charges against Mr. Lazar, because at the last meeting I informed you that in the letters that Mr. Matos read to this committee on behalf of the Arts Commission, Mr. Lazar stated that as the custodian of the records, that he listened to the entire tape, and that there was no portion of the tape that was missing in the meeting, that none of my brother's testimony was missing, that none of my Mr. Kinsell's responses to my brother's testimony was missing. And for the whole year, through 5-6 meetings that we've had, and then at the Compliance Committee, Mr. Lazar finally, after Task Force Member Wolf asked him specifically whether or not that he heard this missing portion, he admitted that the portion was missing. And so my contention is that if, as an innocent man, he knew from the very beginning of this hearing that these statements were made at the hearing, yet the cassette copy which he produced excluded that testimony, and throughout these hearings and all the letters that were written, he continued to say that there was no missing portion of this state, that these statements were not missing, implying that they never occurred. And then later on, he made that. So I would ask you to add. I forget exactly what the charge was, but I asked you to have an additional charge against him for official misconduct. And you said that, and I also stated that in those hearings and in the letters, Mr. Matos had stated that he saw Mr. Lazar on March 8th make a cassette copy, download it from a digital version, and that was the cassette copy that was presented to you, I believe, at the March 22nd hearing that took place. And so what I'm saying is that based on the proof that Mr. Lazar lied to me in my email saying that they can't make these cassette copies, and that testimony was made in front of this committee that they saw Mr. Lazar make the audio cassette copy, and Mr. Lazar continued to insist that this is the original cassette copy, to the point where last month he demanded that you return it to him because it was the original cassette copy. I think I've produced enough evidence to prove that the cassette copy that I was presented with is not the original, is not an actual copy of the original meeting, and that the tape recorded, the tape recording that was presented to you was doctored, and that it was missing a portion. So I would request that you live up to your statement from the last meeting that you do not accept Mr. Matos' testimony in this case because you instructed Mr. Lazar to be here, and Task Force Member Wolf even stated that if he didn't show up personally, that he would take him to, he would personally hold him in official misconduct. And I don't know what else I can do to prove to you that this cassette copy, which was presented to you, was not the original recording of the meeting, and therefore I never received the record that I requested, which was the entire unredacted recording of the meeting that took place. I know it's very confusing, and so there's my time.
DCA 3.
Through the chair, I just want to advise the task force that in the packet you have a memorandum from me and some other materials from the original complaint in this item. And this has been through the process once, and my understanding is that new information came forward. There was a vote to reconsider it. So what you have is all the original materials, and much of what's developed since then has taken place through oral testimony and is not reflected in these materials.
Thank you. Is there anybody to present facts and evidence in support of complainant? Okay, seeing none, I know that Mr. Matos is present because he gave me the letter that he read at the original March 22nd Sunshine Ordinance Task Force hearing. I have listened to the meetings, all of them, and I will have something to say about that later. But I just want to make it clear that while we definitely are requesting that Mr. Lazar appear, there was no vote by the task force not to accept his testimony or his presence. It's not helpful because it's not a knowledgeable person, but I just want everything to be fair and clear. Vice Chair Wolf did make the statement that he would not accept that, but he is here and he's presenting this to me, and it's the letter that he read, and I want that to be something that we have available to us. It doesn't mean that we won't make the statement as a full task force. Our discussions, if we can't make the statement now of what you're saying, but I just want to make that clear. So that, Mr. Matos, do you need this for your 5 minutes? Okay.
I'm Julio Matos, representing the Arts Commission and Street Artist Program Director Howard Lazar. As their representative, I was asked to deliver to you the following statement from Mr. Lazar relating to the revisiting file to 11008, also previously listed by you as number 11007. Dear Task Force members, it is our understanding that at your last hearing on file number 11008, you requested all my written statements, which I provided to Mr. Julio Matos for delivery to you during the course of your nearly 1 year deliberation of this matter. Therefore, we are herewith delivering to you copies of all these statements listed by date, March 22nd, 2011, April 26th, 2011, December 14th, 2011, January 24th, 2012. In addition to having conveyed these statements to you through Mr. Matos, I personally appeared before the Task Force Compliance and Amendments Committee on November 8th, 2011, when the matter was erroneously listed by you as file number 11007. At that meeting, I fully answered all of the questions given to me by the Compliance Committee. At the meeting, I recall that member Bruce Wolf qualified himself as an expert in the processes of audio recording, asserted that he carefully examined the master audio tape recordings which I had given you. And while a certain piece of dialogue had failed to be recorded, he found no evidence of any redaction, alteration, splicing, or editing of the tapes. As we have expressed, the Arts Commission did not delete any portion of this recording. With respect to the recommendation of the Compliance and Amendments Committee, as we stated to you before on December 14, 2011, and on January 24, 2012, Mr. Clark is welcome to send me his suggestions for amending the minutes of the Arts Commission Street Artists Committee, and I will then submit recommended minutes to the Street Artists Committee for its consideration and possible approval. Sincerely, Howard Lazar, Street Artist Program Director, Arts Commission.
Is there anybody to present facts and evidence in support of respondent? Okay, seeing none, the matter's back with the task force. I'm not sure what Vice Chair Wolf represented himself as, but I just listened to these, and I want to make it very clear that if you listen to the tape, you'll hear Vice Chair Wolf say that he, in order to make a determination of whether there was a splice in the tape, he would have to have some special audio recording room. So we've heard this case many times, and there's been several mistakes made that were mistakes partially by the administrator, partially on the task force's fault, and apologize to everybody for them. Be that as it may, there's still some interesting things. I had written this down, but I got this from Mr. Matos. The Clarks had represented. I'm sorry, I keep referring to you in the same way, but I'm sure you're used to it. The complainant had asserted, and his brother had verified that. Mr. Matos had read for Mr. Lazar that he did listen to the tape originally. And he does. He says, as custodian of the tapes, Howard Lazar listened to the tapes in their entirety in order to verify that they had not been altered. That's from April 26. He originally said, I listened to the tapes in their entirety in order to verify that they had not been altered. Again, what you have before you is the entire unredacted, unaltered original recording of the meeting. But at compliance and amendments, he admits that there's a portion missing, and the portion missing is kind of in the middle of the tape that I listened to, and I listened to it over and over again. And there's a section, I think the Clarks might be able to confirm this, where Robert Clark says, I have some questions about these figures. Then there's kind of an odd beep, like a zit kind of sound. And then it says under public comment, you're under public comment. And that's the portion where both parties admitted that there was something missing, although the hard part here, I think, for the task force is we're not here to determine whether it was purposefully deleted or not. I think that's a really serious matter. I'm not sure if that's something the district attorney would address. It's something we might want to ask our counsel, but we can't make we can make determinations based on the actual Sunshine Ordinance, but we have no way of proving. People aren't under oath. People aren't. There's no analysis done of whether something was actually purposefully spliced, although there's clearly you've clearly made the case that there's something missing, and Mr. Lazar has admitted that this portion is missing. At the DCA 3.
Through the chair, in response to your comments, I can't refer you to a section of either state or local law that would provide that it's an offense to alter a public record. I'm fairly certain there is one, but I haven't done that research, and it's not within these statutes to my knowledge. Under the Sunshine Ordinance, however, I believe the complainants are making the case that they have not been provided with the full record that they've requested, and that failure is a willful failure. So I think that is before the task force.
I also just wanted to remind, and then I'll go to Member Snow, that when it came back before us, it was not agendized properly because of the issues that were going on administratively. And so we had a order of determination with that before we had been able to listen to the tape. And when it came back before us, I couldn't make this motion, but I'm just reminding the task force that I had wanted to make the motion because we were rehearing the order of the violation of 6714C for, this says it's not quite right, for failing to record the meeting, the full meeting, 6716 for failure to include the missing dialogue in the minutes, and 6721E for failure to send a knowledgeable representative. But we couldn't do it because it wasn't agendized properly. So I'm just making that motion. Member Snyder.
Yeah, that was my question. Is the only reason that it's before us now on reconsideration was because we, the last time around, the agenda, we determined that the agenda was improper and it had to be moved?
Well,
but there are no substantive. Is
that and the Clarks wanted to add a willful violation, and I didn't feel comfortable. We remember there was some written documents that said it hadn't been redacted or altered in any way, but there was nothing there that said I listened to the tapes and they were not different. And that's what I went back to go and research. So, but now we have it. That's why we requested this. So we have it in writing of him saying, I listened to the tapes, and there was nothing altered. But then at compliance and amendments, he said it is missing. So now we have this verification that he has made those statements, not just that they were not redacted or he didn't do anything to them, but that he listened to it and nothing was missing, which is what we were looking for the last time.
Through the chair, I haven't been through all of the hearings on this, so perhaps I'm in error, but my memory was that the original determination, the task force didn't find at that time, based on the evidence before it, that there was sufficient evidence to find a failure to provide the full record. So my recollection was that it was a more limited determination, and then when the complainants brought forward this additional information, the task force decided to reconsider the matter and set it for a new hearing.
So is there any further discussion, or should we go to rebuttal? Member Neem?
Yeah, I have a question. Maybe my recollection is missing here, or maybe I'm recalling too much, but it seems to me that the two sides were going to get together to try to develop some transcript of the missing portion of the tape. And if either the complainant or the respondent will correct me if I'm wrong on that, but if I am right, if my recollection is correct, I'd like to know what progress is being made on developing that transcription.
Yes, you're accurate that was one of the partial things, and I did I've been waiting for the final conclusion of this before we complete this, but my brother and I have made a short statement, which I think we presented to you a year ago, so you may have lost it, which is the missing portion of the statement that my brother made, which we would like to have included in the minutes. So, I mean, we're prepared as soon as you make a final decision because we want to see what your final decision is. We're ready to, present this to Mr. Lazar as a part of the resolution of this case.
Is there any further discussion? Okay, seeing none, we'll go to rebuttal. Mr. Matos would have 3 minutes, and then the complainant will have 3 minutes. Mr. Matos, do you have anything to add? Okay, so the record will reflect that the respondent said from his seat that he does not have anything to add. So Mr. Clark will have 3 minutes.
To try and simplify this at this point, what I'm saying is that right from the get-go, from the very beginning of this, Mr. Lazar represented to this task force that my complaint was unfounded because there was no portion of my brother's testimony or Mr. Kinsell's response to my brother's public comment that was missing on the tape recording that he presented to you. And throughout these hearings, he's continued to insist that this was the original recording and that there was nothing missing from the meeting, that this was the complete meeting. And all along, while he represented that to you, he personally knew that that was not true because he heard the statement. He was present at the meeting. He heard the statements made. And at the compliance committee, I believe, after his testimony was made, he never voluntarily informed this task force of the fact that he could verify that those statements were made and were missing. It was not until Task Force member Wolf at the very end commented to him that, oh, well, you're claiming you couldn't have doctored this recording because you were sitting on the other side of the table, so therefore you were present at the meeting. Can you verify whether these statements were actually made? And that's when he admitted that the statements were actually made. And that's why I'm saying to you that I believe that he presented you with a willful, fraudulent copy of the meeting, trying to convince you that it was true. And for your information, it is Penal Code Section 134 of the State Penal Code that relates to preparing false evidence presented to a task force like this. So there is a penal code section if I can prove that that was the case, which I will go forward to the district attorney because I think there is evidence that he came in here representing this to be the true copy because he continued to say it was the only copy that the Art Commission had ever made, that they only made digital copies, and he continued right to the very end until now, even claiming that the cassette copy he presented to you is the original copy, to the point where last month he even demanded you return it at the end of last month because he needs to have that back. And so what I'm saying is that an innocent person who knew that these statements were made would not have waited a year to step forward and volunteer that knowledge and information to you. He would have said it right away instead of writing all the opposite in all his letters and statements before you.
Thank you. The matter is back with the task force. I'm gonna make my motion that I made before when it wasn't properly agendized, but I'm gonna add. So I move that we find Mr. Lazar in violation of 6714C, specifically the section that says that they're required to. All right. Hold on a second. This is a street artist meeting, right? So they're not held here at City Hall. So 6714C doesn't apply to them. Correct? Is that correct, DCA 3?
To the chair, DCA Jerry 3, that is correct. This section applies to City Hall hearing rooms that are equipped with audio and video equipment.
Okay. So in our hearing on case 11085, the Library Commission, we made the argument that the phrase each board and commission would be interpreted to include all parts of the board and commission, including its committees, because the committees do the work of the parent commission. Now, this is something that is slightly confusing in the Good Government Guide. There is some information about it, but we have a concern of separating the standing committees from the parent board and commission, especially in the case of the Arts Commission, because the Arts Commission, oddly enough, approves its standing committee's minutes. So you can read it in their minutes. So they're part and parcel. They themselves seem to include them. And the concern we had was that, like the Board of Supervisors, sometimes their committees, standing committees, are the places where public comment is heard. So based on that, I'm going to change it to a violation of 6714B for failure to provide an audio recording of a regular meeting that was not erased or destroyed, specifically erased. (6716) for failure to include the admitted missing dialogue in the minutes. And 6721E for failure to send a knowledgeable representative to the hearing. And I'm going to make it in a willful failure under 6734. Based, I'm sorry, DCA 3?
I was just going to add, Chair Johnson, that I believe the original complaint cited 6721. I don't recall if it specifically said B, but this is a public record to the extent it exists. And if the full record was not provided, then that may also provide a basis for a violation.
The tape is considered a public record?
Yes, Chair Johnson.
Okay.
6726, withholding kept to a minimum. Is that the one you're?
Through the chair to Member Snyder, I'm citing section 6721, which is the general process for gaining access to public records. The tapes themselves are also public records, so to the extent the full record was not provided, that may constitute a violation of that section.
I have a question about that. In the case of the tape, as it exists, it seems like that's the only record that exists. If a portion is missing, is that what would be considered the section that might be missing?
Chair Johnson, I believe the allegations presented by the complainants are that there was, at least they believe, a full tape that had been altered willfully by the respondent. To the extent the task force believes that is the fact, then that would mean that the respondent did not provide the existing full record that existed. It really depends on the findings of the task force.
I think if we did go with 6721, we would probably want to specify 6721A, which says every person having custody of any public record or public information, etc., shall, etc., permit the public record or any segregable portion of the record to be inspected and examined.
Okay, I personally am going to make the motion that I was going to make because I'm not comfortable saying that I know for a fact that he erased the tape or that there was another tape that existed. I personally am not comfortable saying that we proved that. Now, I agree with what Mr. Clark said, that it took a long time for Mr. Clark to come in and admit that that section was not there. So for me, that's the willful failure part of it. Now, that could apply to, willfully not providing a record, but because I don't feel like we have the information in front of us, or maybe even the authority to make a decision about whether it was fully tampered with. I don't know for a fact that the tape exists or not. Outside, I don't know how it originally existed, but we do know that we have an admission that that something wasn't recorded, although Mr. Lazar stated that he didn't know how that happened. So I'm going to make the motion so that it's clear for our clerk, and then if somebody wants to add to it or whatever, we can do it from there, if that's okay. So it's what I said before, 6714B for failure to provide an audio recording of a regular meeting that was not erased or destroyed. 6716 for failure to include the known missing dialogue in the minutes. And 6721E for failure to send a knowledgeable representative. And then I would say it's for pursuant 6734, willful failure.
Second.
So now, is there any discussion to add? If anybody wants to add anything to that, Member Costa.
Can I just make sure I totally have it? So 21C, 16.
No, I didn't put any of the 21s in there. I personally did not put the 21s in the motion.
What was the one for failure to provide audio?
6714B.
14B. Okay, that's what I wanted to know. So 14B, 16, 21E, and 34.
And 6716.
Mm-hmm. I said that.
And, yeah.
Okay.
DCA 3?
Just to address one issue that you raised in your comments, Madam Chair, whether the task force has the authority to find that there was a willful failure to provide the full record based on this. The task force does have the authority, like any body making findings of fact, to conclude from circumstantial evidence that something like this happened. Whether you feel comfortable concluding that or not is another matter, but you do have the authority to do so.
So we would base it on the things that had been presented to us, the documents and the statements.
It is possible for a finder of fact to conclude from the evidence presented that there is circumstantial evidence that this tape was altered. whether there's sufficient evidence to make that conclusion is up to the task force.
Is there any discussion on the motion, or should I? Okay, so I'm going to go to public comment on the motion.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. A couple years ago, I brought the rent board here because they're in the same building as the Arts Commission, and they said we don't have to record our meetings because we're not a charter commission and yada, yada, yada. And they come up with all these reasons why they don't have to, but I think 12 years after the 1999 Prop G, I think any city body here should know that a couple $100 for a recorder in a non-government building which doesn't have facilities is not that big of a stretch on the budget. The rent board now does record their meetings, and they make those available on their website so anybody can listen to them. So all I would say to the Arts Commission is if they have a problem with not being able to record, go up to the rent board and ask them to borrow their recorder. I'm sure they'll let them do it. The issue here goes back to something that's been talked several times earlier this evening about keeping more detailed minutes. If they keep minutes, then all you have to do is listen to the audio tape and look at the minutes, and if you see one word or one sentence that is in the minutes that isn't on the tape, you know something was missing from the tape. Because the tape should have everything. The minutes won't have everything, but if there's, say, a 5-minute gap, and those minutes say that there was something done during that 5 minutes, and there's nothing on the recording, you know for a fact something's missing from the recording. And the other thing I'd like to mention here is another issue that's been brought up tonight, and is the cost of non-compliance. The Clark brothers have been here for over a year. They have consistently come back again and again and again. They've gotten different stories from different people. In fact, I have to say, in my personal opinion, and I'll clearly market that, the reason Mr. Lazar is not here is he knows he hasn't got a leg to stand on, and he would rather send somebody who can read a statement which can't be questioned, and he can't be questioned. So he's not here simply because he knows they're in the wrong and basically doesn't want to show up to pay the piper. The Arts Commission has some real serious problems, and I've been addressing them in some of the things, and I know Mr. Warfield has, because they're doing what some of the city bodies and commissions do. They come up with all these, years after the, and one last thing, the Sunshine Ordinance also says when you upgrade your equipment, whether it's computers or whatever, you have to take Sunshine into consideration. And so 12 years after the 1999 version, they're still saying we can't record meetings, or we don't know why the meetings don't get fully recorded or whatever, is really just, to me, a sign of incompetence more than anything. You can get a recorder, and you can do a good job, and that's all it takes.
Is there additional public comment on the motion? Okay, seeing none, public comment is closed. I have a question about my own motion. Since this has already been before compliance and amendments, would we be forwarding this to ethics or just finding an order?
Chair Johnson, because this matter is here for reconsideration as if there's never been a determination, so it starts at the same point.
Okay. So it would be to send it then to compliance and amendments?
Referrals are up to the call of the chair.
Okay. Is there any discussion about that? Do we want Member Neem?
Well, a question, I guess. What would our instruction be in the order of determination, particularly since what we're dealing with here is a missing portion of tape? What are we going to instruct the respondent to do?
Well, there are two things we had discussed. One, in the past, we had discussed having them work with the complainant to provide in the minutes something that details this in the minutes, and then putting something like we had a malfunction with our tape, and if you look on our website, there's a note on there that says portion missing. So we could ask them to do that. That's why I was asking about sending it straight to ethics, because we don't really have, we've already been through this. We could come back through, we could send it to compliance and amendments and see if that has been done. But it's been with us for so long. And part of the reason why it's taken this long is some of it was administrative. So I don't know what the task force wants to do, but I think that it's a serious matter. This portion is missing, and the clerks may have to take it to a different enforcement authority. So we might want to refer it to the district attorney. I don't know. What does the task force think, Member Nee?
Well, in light of what DCA 3 has told us, basically, since this is a reconsideration, we're starting out at square one. My own thought off the top would be send this to compliance and amendments and see what happens, and then we go from there, depending on what does or doesn't happen. And we, if we go to ethics now or the DA, let's put it this way. I think if we've gone through the CNA step and it comes back here, then I think we have a stronger case if we go to ethics and or the DA.
So it would be the motion, currently it would be the motion as it stands, and then sending it to compliance and amendments.
Well,
And
we're sending it to committee is at the call of the chair, but certainly that would be my recommendation.
To see if they've worked out the minutes and the putting the, so we would add that to the motion. Who seconded it?
I did.
Okay, so we would add to the motion that we're asking them to recreate, to put in, not recreate, but to put in the minutes a reflection of the missing portion of the tape, and then to mark the tape that it has a section missing, and to see the minutes.
The second will accept.
Okay. Does that make sense, Ms. Osbury? Can I help you? You want the full motion repeated? Okay, so the full motion repeated is 6714B. It's to find Mr. Lazar in violation of 6714B.
6716.
Well, wait, for 6714B for not having an audio recording of a regular meeting that isn't erased or destroyed. 6716 for not having for failing to having the missing portion on the minutes, in the minutes. And 6721E for failure to send a knowledgeable representative to the hearings. And it's willful failure, which is under 6734. We're requesting that Mr. Lazar work with the complainant to get have the minutes reflect the missing portion, and to mark the tape in some way that demonstrates that there's a portion missing and refer to the minutes. So when you're ready, can call the roll.
So on the motion stated by Chair Johnson, Member Snyder?
Yes.
Member Nee?
Aye.
Sorry. Member Monet?
Aye.
Member Costa?
Aye.
Member Chan?
Oh, I'm sorry, he left
Absent, okay.
at around 7:30.
Member West?
Aye.
And Chair Johnson?
Aye. This is going to compliance in minutes.
Okay, there are 6 ayes.
Oops, it's the wrong one. If you could read the next item on the agenda.
Item number 10, file number 11050, determination of jurisdiction on complaint filed by Barbara Thompson against the Board of Appeals for allegedly interrupting her during public comment.
Move to find jurisdiction.
Is there a second? To find jurisdiction?
Second.
Is there any public, is there any task force comment on jurisdiction? Is there any public comment on jurisdiction? Seeing no public comment is closed. Can we find jurisdiction without objection? Okay, seeing no objection, we've found jurisdiction. Can you please read the next item?
Item number 11, file number 11050, hearing on complaint filed by Barbara Thompson against the Board of Appeals for allegedly interrupting her during public comment.
Is the complainant present? Yes. Okay. Is the respondent present? Okay. So the complainant will have 5 minutes, and then the respondent will have 5 minutes.
Thank you. My name's Barbara Thompson, and I'm the complainant in the matter. Thank you for your diligence and persistence in holding out for a long day. I also want to thank Andrea Osbury. It's a pleasure to work with her here after working with her in Oakland, and she's been exceptionally professional. And welcome to San Francisco. After all that, I felt I needed to at least give my 2 cents worth. It's a joy to work with you again, Andrea. I filed this complaint because when I attended a Board of Appeals meeting and I wanted to make comment under public comment, I was told that I had to take an oath in order to do so. The Board of Appeals asserts that I should have said that I didn't want to do that, so I guess if I said I don't want to be abused, then maybe they wouldn't abuse me. But it was very clear to me, given the stance of the Vice President, who's formerly was on the Ethics Commission, so I felt he knew very well what the procedure would be, that that was going to be a demand if I wanted to testify. I wanted to make a public testimony under that comment. I was not making comment, and I believe the Board of Appeals has created a ruse here because I was not making public comment in an evidentiary proceeding. It was a reconsideration. It wasn't an evidentiary proceeding at that time. And I really wish that the Board of Appeals would simply say, gee, we really made a mistake. We should have handled this differently. But that's not the way they have proceeded in this matter, and it disappoints me. It disappoints me because that board does not follow the Brown Act. They said it's at their discretion. They don't have to if they don't want to do so. They don't call votes. They said they don't have to. The city attorney, by the way, has supported them in that opinion. And so I feel this is just another, basically, infraction and violation of the rights that we should have as San Franciscans, and I don't think it's correct. I think to say that perhaps I misunderstood is simply a ruse. I did not misunderstand what was the proceeding was, and I do not misunderstand the Sunshine Ordinance as I've used it since its inception. So that is not of confusion to me. There is no public statement or comment when the board begins its meetings. It says only if you want to have your testimony heard are you allowed to do so, and you have to do so with if you speak under oath. They do make a general comment that everybody's going to stand up in the beginning, and they swear people in, but people come in and out of the meeting, and people make testimony, by the way, without being sworn in. I think it's interesting that the chair followed my conduct in the meeting so that it could be said that I didn't stand for the swearing in, and I didn't because I wasn't going to make evidentiary testimony. And I also want to point out that when I did make testimony, the vice president, who was acting as the president pro tem for the proceeding, argued with me and told me basically he didn't agree, which was frankly wasn't appropriate because it wasn't a discussion item. So to say that if I would have interjected and told the board president that I didn't want to be forced into having to be sworn in to give public comment, I really don't think it would have been taken well. And I think a review, it's recorded, of his conduct towards me would be very clear that that was not an opening for me to do so. Again, I don't believe that with a board that of that level of appeal stature and that level of power in San Francisco, I should have to tell them that I want to be able to testify anyway. And please don't make me swear in. It was under a public comment period. I don't think there's any confusion about that. To say otherwise is a ruse. I would just simply like the board to say, gosh, we should have had a V8. Maybe we should have done it differently. Why don't we change our business practices? But 3 pages of comment excusing this conduct is inexcusable. I appreciate the city attorney's opinion. I don't think that it sides with the department. I think it very clearly states what the elements are, and I think it's clear. The Board of Appeals needs to follow the Sunshine Ordinance, and I ask for your assistance in making them do so since they aren't doing it voluntarily. I'm available if the board has questions. I'd be happy to direct responses through the chair.
We may have questions, but it will be after the respondent has an opportunity. Thank you. Is there anybody to present facts and evidence in support of complainant? So seeing none, the respondent will now have 5 minutes.
Thank you. Good evening. My name is Cynthia Goldstein. I'm the Executive Director of the Board of Appeals. And before addressing Ms. Thompson's complaint directly, I wanted to give the task force some background information on the board. It's important that the task force understand that the Board of Appeals is an adjudicatory body created under the city charter to provide the public with a final administrative review process for appeals relating to a wide range of city determinations. And in many instances, these appeals have a direct bearing on the livelihoods of those individuals coming before it. Such was the case with the appeal being heard when Ms. Thompson chose to speak on June 22nd. The board was considering whether to uphold the suspension of a tobacco sales permit of a business that was found to have sold tobacco to a minor. And when deciding appeals, the board holds evidentiary hearings to determine the facts upon which it renders its decisions. And at these hearings, the board considers written briefs and oral evidence presented as testimony. And since the board can consider the effect of a proposed permit on the public interest and surrounding property and residents, the board often hears testimony from members of the public who are not parties to an appeal. The City Charter, Section 14.104, and the Business and Tax Regulations Code, Article 1, Section 30, give the board authority to determine the rules of evidence that will govern the hearings of adjudicative matters. To create a fair decision-making process, the board has adopted rules to ensure that due process is provided to the parties and that the evidence upon which the board bases its decision is relevant and reliable. This requires that the board members make credibility determinations of those testifying, and in an effort to ensure the veracity and reliability of this testimony, the board has a long-standing practice of asking persons who intend to give evidentiary testimony at the hearing to do so under oath. People wishing to give public comment that is not evidentiary testimony are not required to take the oath. So Ms. Thompson is correct that the oath is not a requirement of persons giving public comment unrelated to an agendized appeal under general public comment. And indeed, on 2 occasions, May 18th and May 25th, 2011, Ms. Thompson spoke under general public comment without being asked to take the oath. And perhaps this is where the confusion stems. At the June 22nd, 2011 board meeting, Ms. Thompson did not speak under general public comment, but instead chose to speak under the public comment portion of an appeal hearing. When the presiding officer asked the board's legal assistant to swear her in, Ms. Thompson didn't hesitate. She expressed no objection whatsoever to taking the oath, and to the contrary, when I reviewed the video of the hearing, which I have here, and I'd be happy to play it if you'd like, Ms. Thompson replies, "That's fine," when the presiding officer asked her to be sworn in. Ms. Thompson offers no evidence to support her claim that the presiding officer was going to deny her the opportunity to speak unless she was sworn in, and that she was asked to take the oath in as retaliation. I've personally observed board members ask witnesses to take the oath in the middle of a hearing. This is not the first time this has occurred. If Ms. Thompson had voiced any objection whatsoever to taking the oath, the presiding officer would have explained that she was not required to take the oath if she wished to give public comment, but only if she wished for the board to give her comments evidentiary weight. The board members had no way to know that Ms. Thompson desired to provide general public comment instead of evidentiary testimony at the appeal. And it's highly unusual for someone to speak during the public comment portion of an appeal hearing, except for those who do wish to provide the board with evidentiary information. And in fact, Ms. Thompson's testimony at this hearing was evidentiary in nature. She introduced herself as a resident of the neighborhood where the subject store was located, and someone who has known the store owner for over 20 years, and then she proceeded to present information that directly challenged the veracity of the testimony given by the representative from the Department of Public Health, which is the department that had issued the permit in question. That said, when the board received Ms. Thompson's complaint, it realized that perhaps it had made a mistake and that information provided to the public on the process for swearing people in could be improved. And as of the very next board meeting on June 29th, the instructions read at hearing were revised to clarify that the oath is only required of those who want to have their testimony considered as evidence. This information was also added to the board agendas beginning on July 13th, 2011, and I have copies of these documents that I'd like to distribute to the task force, and I have a copy for the complainant. Given all of the above, given that the board has exclusive authority to determine its rules of evidence, and that Ms. Thompson's consented to take the oath on June 22nd, the board's willingness to hear public comment from those who do not elect to be sworn in, and that the board has taken steps to clarify its process about the swearing in option, I respectfully request that the task force find that the Board of Appeals has not violated the Sunshine Ordinance and that this complaint be dismissed. If I may give to the clerk the copies.
Were you done, Ms. Goldstein? Okay. And is there anybody to present facts and evidence in support of respondent? Okay, seeing none, the matter is back with the task force. Member Snyder.
Ms. Goldstein, could I ask you a couple questions?
Absolutely.
You said that this is not the first time that somebody who is speaking in the middle of a public meeting is asked at that time to take the oath. Actually, let me start earlier. So the regular practice of the board is to administer the oath at the beginning of the meeting before the agenda starts?
That's correct.
And is there an announcement made before that oath is given? You need to take the oath if you are planning on submitting evidence. Is there a sort of general statement as to who needs to take the oath?
Yes, in fact, that's the statement that we clarified after this complaint was filed, and it was just distributed. So if you look at the section that's highlighted in yellow, you'll see the portion where we added a clarification that says it says, now we will swear in or affirm all those who intend to testify. If you intend to testify at any of tonight's hearing, in the part we added, and wish to have the board give your testimony evidentiary weight, please stand, raise your right hand, and say, I do. And then we also added a statement that says, please note that any member of the public may speak without taking an oath pursuant to their rights under the Sunshine Ordinance.
So does someone make this announcement, or is this just?
No, it's in our agenda, and it's made verbally at each meeting as part of the beginning process of the meeting once we call the meeting to order.
Okay,
This is what you added, correct?
Just
Yellow.
the part that's highlighted in yellow is what we added.
Okay.
The part that was there not in yellow is what we said during the time on June 22nd and previously to that.
All right, so you said this is not the first time that someone has been required or asked to take the oath before, in the middle of the meeting after this announcement has been given. How often does that happen?
It's hard to quantify. It happens on occasion. I wouldn't say it happens at every meeting. Typically, we tell people they need to be at the meetings by 5 o'clock, so they're in the room at 5 o'clock and that they're all there to take the oath. But if the presiding officer or another member of the board recognizes that someone was not in the room at the time that the oath was given and they're standing up to speak during an appeal hearing, they will be or may be asked if someone recognizes that. We don't track every single person in the room to make sure we know who has and who hasn't.
So what criteria does the presiding officer at the meeting use to determine whether somebody should be asked to give the oath in the middle of the meeting versus at the beginning?
I think the criterion would be if they recognize that the person hadn't been there or hadn't stood up at the time that the oath was given. And perhaps in this instance, that was part of a distinction that Ms. Thompson may have been in the room, but chose not to stand up when the oath was given. So that would be more easy to identify, possibly, than someone just wandering in the room later.
Is that made clear in any policy? Is there any criteria that's written down for the Board of Appeals to alert the presiding officer as to how they're to make the decision of whether someone needs to be given the oath in the middle of the meeting?
I think the only criterion is this issue about if they're giving evidentiary testimony. So if the presiding my guess, I'm not in their head, but my guess would be if the presiding officer feels that someone who didn't stand to take the oath is stepping forward during an appeal hearing, and they expect that person is going to give evidentiary testimony, that they would ask them to take the oath.
How are they to know that, whether they're going to give evidentiary testimony or not?
I think it's just because in the vast majority of circumstances, somebody standing up during an appeal hearing, as opposed to during the general public comment portion of our meetings, which is at the beginning, someone standing up during an appeal hearing is there to speak about the appeal and to help the board, sway the board one way or another.
I have one question about that. If somebody wanted to speak on an item, not the general public comment, can they speak on that item without being given the oath, but with the understanding that their testimony would not be given evidentiary weight?
Yes.
Okay. So,
and that's what we hope to make clear by adding that additional language.
and so when just in follow-up to that, when somebody stands up to and during a hearing, not under general public comment, but during whatever kind of a hearing, are they asked, do you wish to make evidentiary, or only if you recognize that they were not given the oath at the beginning?
We do not ask whether someone intends to give evidentiary testimony. It's basically assumed that that's why they're standing up. I mean,
So
if they're
if-
there to speak on that item, which is what they should be speaking about, then we assume that they're there to give some evidentiary testimony. But they could say, and now we hope it'd be clearer both to our board members and to the public, that if someone would prefer not to take the oath, they could say, I prefer not to take an oath, and I would be happy to have my public comments taken only as public comments and not given any evidentiary value.
Okay, thank you. Does anybody else have any questions? Member Nee?
Not a question really, but the respondent Ms. Goldstein has offered to show us the relevant portion. She says she has a recording of it with her, and I'd like to see it. I think it would be very helpful for us in making a determination if we saw what actually happened.
Does that have the capability of doing that? We need to tell the building now it's too warm.
I noticed the oath language at the bottom of the page here doesn't say.
You're right. It doesn't say that. I saw it. This really surprised me. Gallup did a poll, I guess national.
Down in here. You might have to put the mic up to its. Okay. Thank you, Mr. Pitts. She has on almost the same clothes.
Correct, I'm not a paid advisor. I'm a master dresser.
Oh, he's.
And
Comment on this item?
So impressed.
She chose not to stand and be sworn in.
You don't have a.
Solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Thank you.
Fine, thank you.
Thank you. Is there any public comment on this item?
Victor, would you?
Do solemnly swear or affirm that the testimony you're about to give will be the whole truth.
I can't hear her.
To try again? Before you begin,
Is there
I
any
want
way
to
to
confirm, Ms.
either-
Thompson, that you're not a paid advisor.
That's correct, I'm not a paid advisor. I'm a resident.
Remember, Nee, why don't you go over there near where it is and watch it? And
I have it on screen here.
yeah, but can you hear it? Want to stand up there and listen to it? And well, since he would raise, anybody can if they want to. That way, somebody will have who raised the concern can hear it. You can go watch if you want. I can hear it. I didn't mean to be.
Try it. Also sent out the new California ID. I think we've done everything within our power, and I respectfully ask that the board deny the rehearing and uphold the previous suspension time. Thank you. Thank you.
Thank you. Is there any public comment on this item?
Victor, would you swear her in before she testifies?
It's fine.
She chose not to stand and be sworn in.
Do solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Thank you.
Okay, go back.
Before you begin, I just
Go
want to
back to
confirm,
where
Ms.
she
Thompson,
first
that
got
you're not
up,
a paid
and
advisor.
I'd like to hear
That's
the words
correct,
of the chair.
I'm not a paid advisor. I'm a resident of Bernal Heights since 1979.
And lo and behold, I was happy that they also sent out the new California ID. I think we've done everything within our power, and I respectfully ask that the board deny the rehearing and uphold the previous suspension time. Thank you.
Thank you. Is there any public comment on this item?
Victor, would you swear her in before she testified?
It's fine.
She chose not to stand and be sworn in.
What was it?
Would you sign her?
Solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
Thank you. Can you, are you okay with that? Okay.
Madam,
Member name?
Ms. Thompson, please. Okay, when you were sworn in, apparently you did not object to it. So,
That is correct. I did not object because I knew I still had a right to file with this body regarding the conduct of the proceeding, and I wanted to testify. And when someone says, you did not stand up, you need to swear her in, that's not really a negotiable item.
so you're saying that had you not consented to be sworn in, you would have been barred from testifying?
I feel very certainly that there would have been an adversarial issue regarding that.
But would you have been, the adversarial maybe, but would you have been barred from testifying? Would you have been barred from giving public comment?
I don't know. I can't answer yes or no to that question because it did not occur.
Would you say that, sorry, go ahead.
May I just add that I don't think that you have the full piece when you only see my coming up to the podium. And also, if you looked at the meetings, you would see that not everyone that is testifying from departments is being sworn in at the beginning. As I said, they come in late, they're not confronted about standing. And they still give testimony, and the board considers with great weight that testimony in that evidentiary proceeding.
Member Snyder?
Ms. Thompson, would you say that your testimony was altered or abridged in any way because of the actions or words of the chair?
Yes, I felt that if I would have said more, it would have adversely influenced the shop owner, so I restrained myself.
That was as a result of him telling you that you had to be sworn in?
Absolutely. I didn't want that to adversely affect the decision. This was already somebody from the neighborhood who was facing severe hardship for having sales prohibited and suspended.
But how? But you did testify and you did speak. I guess I don't see the link between what the words of the chair asking you to be sworn in, and what you're saying about truncating what you said or limiting what you said or what you testified to.
You asked my opinion, and I'm telling you, I restrained myself. If you look at other meetings, the one before that, I was very direct with the board and quite adamant about the board conduct. I did not speak with that veracity at all under the item that pertained to someone where someone else could be influenced by a president who was already observing my conduct in the meeting and not others, and telling me that I had to be sworn in because I didn't stand up.
Were you there? You were there when they did the initial announcement and
there.
oath, and you didn't stand up?
No, because I wasn't. If, in fact, as Ms. Goldstein is saying, I was not expecting my testimony to be evidentiary. I didn't elect for it to be that, and no one in the board asked me that. Certainly the president asked me that. I was there for public comment, not for evidentiary. If the board decided paternalistically that it was going to then determine that my testimony was evidentiary, that was on them. I didn't represent the individual. I didn't go as a witness for the individual. I went as public comment. I wasn't considering that the board ask, and I was not expecting the board to consider my testimony as evidentiary. I've had a number of evidentiary proceedings and matters before the Civil Service Board and the Fire Department, the Police Commission, the Fire Commission. I'm very clear about when an item in testimony is evidentiary. I was making public comment.
Ms. Goldstein said that you testified, I think, twice earlier, or in 2 prior meetings at the time for public comment, and that this was the 3rd time, and that you spoke at the time for public comment for this particular item. They're, making a distinction about the time. Is that true? First of all,
Well, I know that I made comment at least twice about the board's failure to call the item for vote and call roll and count the ayes and the nays as stipulated in the charter, and in pretty standard, certainly it is under Robert's Rules of Order. And so at least 2 occasions, I believe, and this is quite a while ago, almost a year, I did make public comment or public testimony. I mean, that's what, if we're talking about testifying, that's what I mean. And one time, because I felt it was so dismissive the first time, I asked that my comments be included with the minutes. I noticed that they're not included on the minutes because I pulled them up here in the board room, but I don't know if they're on file. So I did give written testimony, a written statement also. And I made comment under another individual who was suspended. But again, it wasn't evidentiary.
Okay, we can't have just a running dialogue. Is this responding to your question?
I'm done.
Okay. Is there additional questions for Ms. Thompson or Ms. Gold? Okay, so at this time we'll have a rebuttal, and the respondent goes first for 3 minutes, and then you have 3 minutes.
Thank you.
Okay. So the respondent will have 3 minutes.
Thank you. Just to reiterate, Ms. Thompson would most certainly have been allowed to testify without taking the oath. Period. I disagree that I don't understand how she could suggest that what she was testifying to was not for evidentiary value, since what she said was that the departmental representative was making false statements. And if she didn't want the board to consider that as evidence in their deliberation about whether or not to grant a rehearing, I don't know why she would have said it. The oath is an important tool that the board uses to encourage people to take its proceedings seriously and to tell the truth. And we have taken corrective action to try and make it clearer to the public and to the board members when that oath is something to be used and when it is not. So I appreciate your consideration.
Thank you. The complainant will have 3 minutes.
Again, I had no intention of my testimony being evidentiary. It's very easy at Monday morning quarterbacking for the board to come forward and to say it was. I was definitely concerned about the misrepresentation, and I made a comment about that. I also made comments about the demographic profile of the number of matters that are brought before that board on the and that I felt that there was clearly an inordinate number of people of a particular ethnic group, at which point the board president told me that I didn't know what I was talking about, basically. The issue with the Sunshine Ordinance and the ability to provide public comment is not to be squashed based on whether or not the board president decided that they were going to make my testimony or arbitrarily decide that it was evidentiary and then call me forward and tell me that I have to be sworn in. If in fact this wasn't simply a ruse, the president would say, do you intend to make evidentiary testimony? If so, we will need you to be sworn in. That was not the case. Because it came on the back door of the fact that I had been critical of the board and its proceeding and its failure to follow the charter, the Brown Act, and the fact that the board president acting was watching whether or not I stood up, and not Dr. Ojo, who wasn't in the room at the proceedings and was never sworn in and gave testimony, is just disingenuous. They made a mistake at the very least. They're acting arbitrarily and capriciously, which is what I think they do when I look at the way they violate the Charter and the Brown Act. But this was not that there was any kind of misunderstanding. I do not have to, as a citizen of San Francisco, it's my firm belief, and I hope that you'll uphold this, I do not have to be sworn in to make a public comment. And if in fact I wasn't sworn in, they could have simply dispelled that. I did not feel I had an option. And it is not up to me to tell them that they're violating the law. And in fact, when I do, when I tell them they're not following the charter, they don't really care anyway. So no, I had no belief that if I said anything other than, fine, I will do that, that I would have been able to proceed. Because they have wanton and blatant disregard for the law. Thank you.
Thank you. Member Nee?
Ms. Goldstein, please. Has the board ever suspected that somebody giving comment under oath was not telling the truth, the whole truth, and nothing but the truth?
Again, I can't speculate as to what is
I
in
mean,
the
let's-
minds of board members. I certainly have thought that.
Okay, and what would happen if the board suspected that somebody lied under oath? Is there, does the board actually have the power, the authority to place somebody, to find somebody in perjury, guilty of perjury, and to somehow penalize or prosecute that person?
I do not believe so. Again, I think that the oath is a tool that the board uses to try and encourage truthfulness and the seriousness about its proceedings.
Thank you.
I have one question for you. You had said that the Board of Appeal was created by the charter. Does it provide you with the authority to create rules and regulations?
The charter
Like
provides that, yes.
For the Board of Appeals specifically?
There's another provision in the charter, the one I cited, 4.104, that does for boards and commissions generally, and then in the
Okay.
Business and Tax Regulations Code, there's a provision that deals specifically with the Board of Appeals.
Okay. Thank you. DCA 3, just on a side note, that's different from the task force because we're administrative, right? The ability to make the rules and regulations.
Chair Johnson, I'm not quite sure what your question is. Do you mean the charter section?
Yeah, we don't have that authority. The Sunshine Ordinance Task Force.
You do have the authority to make rules and regulation governing the provision of public comment, so long as it's consistent with other portions of the law.
And that would be true of the complaint procedure as well?
Yes.
Okay, thanks. Is there any? Seeing no further discussion or motion, should we go to public comment? Is there public comment on the matter?
Members of the task force, Ray Hartz, Director, San Francisco Open Government. I actually had my own experience with this very issue before the Board of Appeals. And it was the first meeting I went to, and they said, if anybody plans to give public testimony, please stand and take the oath. And I had come to make general public comment and to view one of the cases. So I did not stand up. And then the case came up, and I heard one of the persons who had sworn to tell the truth lie. And it was regarding a case heard by this task force where that task force had directed the person to provide information to Ellen Tsang regarding her case before the Board of Appeals. And then I subsequently walked out into the hall, and Ms. Tsang was asking him, are you going to give us this information? And he said, no. Then he went into this hearing and said, I gave her all the information. And so when I got up during public testimony, it was like, oh, well, I heard him say he wasn't going to give something that this task force had told him he needed to give her. And he just now said he gave her everything. And I made my comment, I sat back down, and then they got into the discussion, and the very person who was presiding at that meeting was the person who brought up and said, well, Mr. Hartz didn't take the oath at the beginning, so we really don't have to consider what he said. And I went, oh. So I think what we have here is a difference between them saying, you're not barred from giving public testimony, but if you want it considered in our deliberations as evidence, then you have to take the oath. And so the very next time, of course, I got up and I said, well, I'm making public comment or I'm not making public, I'm to take the oath so that I'm not hampered further on down the line. And I certainly was never offered the chance to take the oath the second time. So their procedures are really willy-nilly. I agree with her, the plaintiff or the complainant in complete, when they give the oath at the very beginning of the meeting, and if your case is halfway down the agenda and you decide, well, I'm not going to come at the beginning of the meeting, you can completely miss out on it. And I have never seen them actually say, do you want this considered as evidence, or do you simply want to make public comment? And I don't think it's up to the public to have to figure out which of which is mine. It's up to the board to make it clear to people that this is the way it is. If you're giving evidence and you want us to consider it in our deliberations, then you have to take the oath. If you're not giving evidence, or you don't want to, or you accept the fact that even if you say something in public comment, we don't have to consider it, then you can get away without taking the oath. And I really do have a question as to whether or not this is a technique being used to refuse to consider things which people say in public comment and excusing that on the grounds that it's not technically evidence.
Thank you. Is there additional public comment on the matter? Okay, seeing none, public comment is closed. The matter is back with the task force. Member Nee?
I'm not sure that we have enough here to find a violation. At the same time, particularly in light of what we have heard over the past several minutes from the complainant and from a member of the audience who has experience with the Board of Appeals, particularly with Mr. Hartz testifying that somebody lied under oath. And given Ms. Goldstein's acknowledgement that lying under oath does not necessarily, and the Board of Appeals does not have any kind of prosecutorial authority in cases where there is perjury, I think the board ought to revisit that policy very seriously. And if it was me, I would throw out that entire administering of the oath, because it, as near as I can tell, it doesn't work. It's not effective, it doesn't work, and it does tend to be discriminatory in its application.
Member Snyder?
Yeah, I largely agree with what Member Nee said. There are a number of aspects of the policy that are troubling. What bothers me the most is that there's no that the board doesn't make clear to anyone who wasn't there at the beginning of the meeting what this oath means, or whether it's a choice, or whether they what the significance is if they take the oath or not, or even that they have the opportunity to not take the oath. That's troubling. And personally, I'd like to see it would I think be much fairer and much more open if, in an instance like the one that we saw in the video today, the presiding officer decides that maybe an oath is necessary, if they present it as your revised policy presents it. Do you understand, person who's about to testify, that if you don't testify under oath, we won't consider it as evidence? Do you want to testify under oath, or do you not want to testify under oath? If you don't, it's not evidence. I think that would be a lot better. But the question that we have before us is, looking at 67.15D, that mandates that a policy body shall not abridge or prohibit public criticism. So the question we have here is, in this instance, did this kind of ad hoc administration of the oath abridge or prohibit public criticism? And I just don't see that here. I don't think we have sufficient evidence to conclude that that was the case. I understand why the complainant brought the complaint, and I think it highlights a problem with the consistency of the administration of this oath policy, but I don't think we have enough to find the violation of the ordinance.
So, seeing no motion, the matter is closed. But it's clear that the task force recommends that the Board of Appeal, if they continue to use the oath, which I understand the significance of what you're deciding is sometimes the livelihood of the person who has something at stake. So you want to try to encourage people to be as honest as possible, but at the same time take into consideration that the members of the public need to you can just ask them rather than saying she didn't take the oath, you could have asked. So to make it very clear, as Member Snyder said, that they have the choice and what the choice specifically means. And thank you for coming. So we only have 6 members, and I have a request from a member to take a quick break. Our deputy city attorney is leaving at 9 p.m., and I need to ask the task force a question. There's a jurisdictional question on item 11094. It's item 21 and 22. Do we feel like we need to have DCA 3 here for the jurisdictional issue? It's a nonprofit, and the documents requested are not financial. But we don't have time for you to review everything and have him here. You'd either have to feel like you could do it or not. Okay, so unfortunately at this time we will lose quorum if we take a break, so we have to take a 5-minute break, but I'm going to make it very rigid. I'm coming back here in 5 minutes.
say, so help you Santorum.
Who unfortunately lost Michigan.
Oh.
You know why? It's because Romney's wife owns 2 Cadillacs. That's why. Did you see that? Wasn't that the funniest thing? Oh my God, he in this speech, he was like, I love American cars and I loved Ford growing up and and my wife owns 2 Cadillacs.
Enron tanked Ken Lay's wife was pissing and moaning about they might have to give up 1 or 2 of their 6 houses.
Mm-hmm.
The oath language doesn't say so help you Santorum. You know what I'm referring to? Santorum's diatribe against, tirade against JFK. You didn't see that?
Didn't he also suggest that he wanted religion to be part of, to play a larger role, in essence, to undo the separation between church and state? Right.
Talk like that makes me sick, or something like that. Yeah.
How long ago was this? How long ago was this?
A few days ago.
I missed that whole thing.
I'll see if I can find the link and send it to you.
I missed the whole thing. I don't even remember hearing it. That's amazing that I wouldn't hear a reference to it or see it.
He did. He said what? Sorry. Oh. No, he doesn't. And Arizona. Yep.
I'm going to call the meeting back to
Or so
order.
my Twitter feed says so.
Okay, so ready? Okay. The meeting of the Central Ordinance Task Force is now back in order, and I think that, unfortunately, I apologize, but I think that we need to hear the jurisdiction of 11094 with our Deputy City Attorney present. So if you could read item number 21 out of order.
Item number 21, file number 11094, determination of jurisdiction on complaint filed by Charles Pitts against a nonprofit community housing partnership for allegedly not providing requested information.
DCA 3, are you leaving immediately at 9 p.m.? Are you leaving right at 9? Just a few minutes over. Mr. Pitts, this is only related to jurisdiction, not the merit of the underlying case, because it's a nonprofit. So can you, you had provided to Ms. Osbury, and it's in our extra meeting materials, you don't have it? Do you have it? Okay. So you had provided some information that you said went to jurisdiction. So in your 5 minutes, if you could address that.
Well, it's in the other document, it said that the contract was not to exceed one 1,600,000 something or whatever the number was. And when you look at this document here on this huge screen, you see their budgets, the expenditures, the staff, and you got a 1,657,000 number. So I believe that's just one of their buildings, and they own several buildings. So chances are they're getting more monies from they're getting more monies from this city and county of San Francisco, not just this one. So it looks like they got monies coming in from not only this property, but other properties as well. And I'm under the impression that they had waived jurisdiction. I mean, did they waive jurisdiction at near 4 o'clock?
It's not that, it's what the task force has jurisdiction to hear.
Okay, but if he waives jurisdiction, then he's waiving this part of the process.
But I'm sorry, I don't want to take up your time, but the question in front of us is that it's not a question of whether they fall under 12L. They do, but the documents you're requesting are not financial documents, and 12L only deals with financial documents. That's my understanding.
But see, that's the problem. See, first of all, now we're going into the merits of the case, and that's very separate, whether we have jurisdiction or not. That's very separate.
Can you address that, DCA 3?
Through the chair, the jurisdiction issue is separate from the substantive issue. There could be some overlap in some cases. It does appear from at least the contract documents that I've seen on the controller's website that they receive more city funds than is necessary to qualify under 12L, so they should be subject to the provisions of 12L. So the task force would have jurisdiction to hear a complaint under 12L. There's a separate question, however, whether they're subject to the general requirements of the Sunshine Ordinance, which is separate from 12L and applies only to certain public bodies and not generally to nonprofits. It does not appear that there's such a body.
So do we normally find jurisdiction based on the fact that they're subject to 12L, and then as Mr. Pitts is requesting, then we go into whether those records fall within 12L? Has that been the practice?
That has been the practice.
Okay.
I'm going to add that I've come to this body before, and I was asking for copies of some of my personal files from A12L, and they found jurisdiction, and they went through that whole process, the hearing process. So, I mean, if you look at your history, I should be allowed to have a hearing.
Okay, does the respondent have anything to say based on that?
Hi, good evening. Jeffrey Kohler with Community Housing Partnership. So I would just say that I don't disagree with the jurisdiction. It's that what Mr. Pitts has requested is not a financial document as it's listed in 12L. I think it's 5A.
Okay, thank you. And Member Neem?
Move to find jurisdiction.
Second.
Is there public comment on the motion to find jurisdiction?
There is. Good evening, David Pilpel. As I read this item, the complainant, Mr. Pitts, alleges a violation of 67.25A on page 274 of your packet. The respondent, Community Housing Partnership, is not a city body, as you've just been advised, would not, even under the best of circumstances, be subject to Chapter 67, would, however, be subject to Chapter 12L, Section 12L.5B dispute resolution requires a member of the public to submit a complaint or request to the city agency or department which is a party to and or which administers the nonprofit organization's contract, and only following that process may the member of the public or the nonprofit organization seek an advisory opinion from the Sunshine Ordinance Task Force. I don't believe that Mr. Pitts has done that. You've not heard or seen anything that I've seen that suggests that that has occurred. If that has not occurred, then I don't believe you should find jurisdiction either on the 12L aspect and certainly not on the 67.25 alleged complaint. So I would urge you not to find jurisdiction on the matter at this time. Thank you.
Is there additional public comment? Okay, seeing none, public comment is closed. DCA 3.
Through the chair to the members of the task force in response to Mr. Pilpel's comments, under a previous membership of the task force, the task force, particularly at the urging of former Vice Chair Craven Green, did treat the provisions Mr. Pilpel is citing as jurisdictional issues. Subsequent to Ms. Craven Green leaving the task force has tended not to treat it as a jurisdictional issue, but more of an issue of whether they're going to find a substantive violation of 12L. On balance, I believe Ms. Craven Green's approach was more consistent with the language of 12L, but that has not been the recent practice of the task force.
Thank you. Member Nee.
Mr. Pitts, please. Who is the primary contracting agency with the nonprofit? What is the city agency that the nonprofit deals with primarily? Where it gets its funding?
Okay, I guess I'm a little confused.
Where?
Okay, hold up. Let me let me get some clarity here. So, are we in jurisdiction? Or are we?
We are in jurisdiction.
Okay.
Where does the money come from? With what? Which city agency has the contract with the with the nonprofit here?
DHS. It's right here. See.
DHS, Department of Health Services.
Department of Human Services. It's
Human
right here.
Service.
Let me.
Okay, Mr. Pitts, have you gone to the Department of Human Services and asked for their assistance in this matter?
Okay, but see, you're definitely mixing the issue up because we're talking about jurisdiction.
Have you gone to the Department of Human Services and asked for assistance in this matter?
I haven't, but see, first of
Thank
all,
you.
so see what you're doing is
Sorry,
that.
what was that? Yeah. Okay.
Okay, see, the problem is first of all, the city attorney, he didn't.
Okay, Mr. Pitt, I can't there has to be a question before us. So do you have any further additional questions? Is there any? Okay, so let me ask the task force, is the motion standing to find jurisdiction? Is there any? We can still go the route of having him stated.
I will say that given what we've just been told, I plan to vote against the motion, even though it's my own motion.
Do you want to call the roll on the motion?
Has there been public comment on the motion? Yes,
Sorry,
I believe
please.
there has.
Hold on a second. DCA 3 and then Member Snyder.
Even though this is a jurisdiction question, because you're holding a hearing on it, you've allowed the complainant an opportunity.
I'm sorry.
Then you need to allow the respondent, and then the complainant gets to respond.
The rebuttals. Okay. Member Snyder, do you want to ask a question before we do the rebuttals?
I do, very quickly. DCA 3, I can't remember or find right now where the $250,000 threshold comes from in your memo. And I know we've talked about this before, but in your memo, you say that the jurisdictional question kind of turns on the issue of how much grant money was provided, right?
Yes.
Where does that come from?
Through the chair, section 12L.3 defines a nonprofit organization as a 501c3 that receives a cumulative total per year of at least $250,000 in city-provided or city-administered funds.
So we've held, that's right, we've held in the past that if that dollar threshold is not met, then the entity is not a nonprofit and therefore not subject to the provisions of 12L. Is that the reasoning?
Correct. It's not a nonprofit for purposes of 12L.
Right. Yeah. Okay.
Okay, so at this time, the respondent will have a 3-minute rebuttal and then the complainant, and this is on the jurisdiction.
Hi, Jeffrey Kohler with CHP again. I have no further comment other than that's been presented to the board.
Thank you. And the complainant will have 3 minutes.
This case has been botched. It's been botched by the city attorney. I mean, if you don't find jurisdiction and you don't find in my favor, pretty much what you're telling me is a nonprofit doesn't have to respond. Your city attorney did not get the question correctly. I said in my complaint, right here, page 274, did not respond to request. It wasn't respond adequately. It didn't respond, none of that. It was did not respond to request. So what you're doing is you're setting a very dangerous precedent that a nonprofit does not have to respond at all to any of their complaints. They don't have to respond to anybody. And that's the whole scenario. Are y'all gonna allow a nonprofit not to respond? I mean, are you gonna allow a nonprofit to not respond at all? Even if it was in or not their jurisdiction, or if they did have the right or did not have the right to provide the information, are you going to give them that privilege to just totally ignore the members of the public? I mean, your attorney botched my case. You know, I mean, this isn't much more. It's totally botched. I did not get a response. He's saying respond adequately. Now I'm being jammed up on jurisdiction, when in previous cases, you did not jam me up like this. And of course, I was visceral for the last meeting because, you know, it's been like 60 days, and I still didn't have a clear notice of when I was gonna have a hearing. Of course, and then it gets implied that my request is a waste of time. You know, of course I'm going to be angry. I'm going to be visceral because I'm continuously being made a victim here. I'm a victim. I'm a victim here, and it looks like I'm just continuously being abused by this process. This case has been botched, totally botched.
Mr. Pitts, your complaint has you're alleging a violation of 6725A, and nonprofits aren't subject to that. Can you explain, do you have an explanation for why you believe it is subject to that?
So how am I supposed to get information from them? How am I supposed to get information from them? I've done it before. I've got information from them before. I got information from there before like that, and that's
from a nonprofit?
Them people over there several times. This is like the 5th or 6th information request I've got from them. I mean, and they have failed to properly. They have failed to properly give me the information requested before in those other complaints. You know, I just did not want to continuously. I mean, there's like 4 or 5 that I could be filing against them. So
And then I have one more question for DCA 3 before he leaves. The section that you cited, 12L5B, the dispute resolution, when I read it, it still says additional financial information other than that described or a complaint concerning compliance or noncompliance with this chapter. Doesn't that still relate to 12L, the provisions within 12L, which is financial records and public meeting access? Or
Chair Johnson, I've turned to this section. Do you want to ask me the question again, please?
that section, the first sentence where it describes what the member of the public might be asking for. So it says, who requests additional financial information other than that described in 12L5A above, or who has a complaint concerning a nonprofit organization's compliance or noncompliance with this chapter. Doesn't that mean that the dispute resolution, I read that to mean the dispute resolution is related only to the financial records or the public access to meetings, the things that are in this 12L chapter? Is that?
Well, it's additional financial information in 12L5A has a very specific types of financial information that should be provided by nonprofits covered by 12L. And if a member of the public is requesting additional financial information not covered by 12L5A, then they can go through this dispute resolution process.
Okay.
Madam Chair?
Member Nee?
There is one other possible element that could be brought into this, and it's a question, and perhaps the respondent could answer this. There are some nonprofits that in their contracts with the city agree in writing to abide by the Sunshine Ordinance. So what I'd like to ask of the respondent is whether he is familiar with the contract and whether it contains any such provision. Mr. Kohler.
Thank you. No, I'm not aware of that. I just joined CHP in early January, so I don't know the contracts that well. But I'm not aware and haven't seen anything that I've reviewed like in preparation for this case.
Okay, thank you. Okay. Mr. Pitts, have you seen the contract, sir, between CHP and DHS?
It's actually parts of it are here. I'm not that familiar with it, but I think it still goes back to they should have responded. They did not. They didn't even respond.
Okay.
They didn't respond.
Have you seen the contract, sir?
I'm not that familiar with it to make that determination.
Okay, thank you.
My concern here is that we would be going through the hearing needlessly, because even though we have jurisdiction, it's specific to a specific type of record. And the complaint itself alleges something under 6725A, which is not even something that we have that applies to the nonprofit. I don't know if that's other people's concern as well, but Member Costa?
I think I know the answer to this, but I just want to clarify with DCA 3, if it's okay. So there wouldn't be a requirement of the nonprofit to respond indicating the fact that they aren't bound to respond, essentially, or provide the document.
Through the chair to Member Costa, under the Sunshine Ordinance itself, the respondent does have an obligation to respond to any request for public information. The same obligation does not exist under 12L.
But Department of Human Services is separate, even though it's there. Never mind. Okay, so we have a motion. We took public comment on the motion. Did we take public comment on the motion? Okay. So can you please call the roll on the motion to find jurisdiction?
Member Snyder?
Yes.
Member Nee?
No.
Member Nee, no. Member Manet?
Yeah, aye.
Member Costa?
No.
Member West?
No.
Chair Johnson?
No.
We have 2 yeses and 4 nos.
And so we found that we do not have jurisdiction for this particular complaint. So that closes the matter, which also means that item number 22 will not be heard because we did not find jurisdiction. And I appreciate the parties and the other complaints waiting because DCA 3 is now leaving. If somebody has an issue with DCA 3 not being here, or we do have another attorney on the board, but please let us know. If you could read the next item, which would then be item 12.
Item 12, file number 11088, hearing on complaint filed by Ray Hartz against the Ethics Commission for allegedly failing to include his 150-word summary in the body of his meeting minutes.
The complainant is present. We already found jurisdiction on this at our last meeting, just so you know why there's no jurisdiction item here. And then, but the respondent is not present. Did we hear from the respondent? Ms. Osbury, did you hear from the Ethics Commission about this complaint?
No.
Thank you. Does the complainant wish to proceed without the respondent present? As you know, we've received communication from the respondent several months ago that they would not be attending for this particular case. I know you're aware of that.
Yes, and I really see no reason. They've said several times for several different reasons they weren't going to come, and the simple fact that they did nothing tonight to say they weren't going to be here is pretty indicative of, I think, where we're going to be with this.
Okay. So then you will have 5 minutes to present your case.
Members of the task force, Ray Hartz, Director, San Francisco Open Government. As all of you have already been bored with over the length of time, this is the response to my half-page complaint. I'm not even going to attempt to answer all the stuff that's in there because they have done everything they could to talk about every other thing but one central question, and that is whether or not they have the right to censor public comment, in particular comments which they find are dissenting opinions. In 10054, you found that in the minutes means in the minutes. That's what this is about. In 11054, you found again that in the minutes means specifically in the minutes, and an addendum doesn't qualify. And all of their responses in here were basically saying, well, we've changed some things, so Mr. Hartz ought to be happy and go away and leave us alone. But we have the same case here. Why don't they want it in the minutes? They don't like what I have to say. And they don't want to represent what I have to say appropriately in the minutes. It's the same thing with the Library Commission and same thing with the other bodies I've been here before this task force about in the past. They, initially started to give this typical well, he said one thing and he wrote something else, and they give you all these sort of mealy-mouthed things. And at the one committee meeting, Mr. Munson, who's the vice president of the Library Commission, said, we don't like their comments. And that's the one thing the Brown Act says you're not allowed to keep it out because you don't like the comments. And then they come back and say, well, we're not keeping it out, we're attaching it. But if you take something out of context and put it in another place, yes, you are. It's like the versus between a footnote and something in the appendix at the back of a book. Some people will look at that little number and they'll say, oh, there's an appendix, I should go back and look at that. Some people won't look at it. And if it's taken out of the minutes, that it's very likely that, number one, people won't read it in the first place, and number two, that if they do read it, it's out of context and they don't necessarily understand it in its proper form. Now, the second thing, and the reason I say this is really egregious, is the simple fact that if they took the 150-word statement, and surprisingly, one of the Arts Commission's people, and I'm only saying this because there aren't a lot of people here, one of the Art Commission subcommittees actually did put my 150-word statements in their minutes, where they appeared in the minutes. And all it said is, Mr. Hart supplied the following statement. The world didn't come crashing down. It wasn't the end of time. It wasn't, all these dire things they keep putting up. And all I'm saying is that they want to do, in addition to keeping it out of context, they want to substitute in its place their interpretation of what a person has to say. And I made a comment before the Library Commission just last month because I haven't let them off the hook because they've already got 2 determinations against them. And I said, it's really amazing. I read the minutes, and I'm constantly amazed how I am unable to come up with a coherent thought or make a statement that makes any sense, and sometimes say things that make absolutely no sense. Like in one set of minutes, it said, Mr. Hart said it was like closing the barn door after the barn door was closed. So basically what I'm saying here is there is no real state compelling interest. And that's what the Brown Act says, and that's what the legal rulings on the Brown Act have said, is that for you to deny public comment, then you have to have a compelling state interest. And in each of these cases, I was very careful to do it in a particular way. I wrote my 150-word summary. I read that 150-word summary verbatim, and I used the remainder of my time to expand on the ideas that I had expressed. If they wanted to save themselves some time, they could put my 150-word summary in the minutes, and then they wouldn't even have to bother to summarize it. But that isn't what they want to do. They want to keep my statement out and other members of the public because they don't like what we have to say. And number two, they want to be able to substitute in its place in the official record, in the minutes, their representation of what I say. And that's why this, as in prior cases, needs to be found that they are in violation.
Thank you. Is there anyone to present facts and evidence in support of complainant? Seeing none, the record will please note that respondent is not present. Is there anyone to present facts and evidence in support of respondent? Seeing none, the matter is with the task force. One of the concerns that I have about I shouldn't say one. There are a number of things we should probably respond to in the Ethics Commission's response, because in their response, they allege a lot of things based on discussions that the task force has had, as opposed to rulings and determinations and findings that it has made, which is a little bit separate from what we're considering here. But I do have a concern that there was some. I've said this before, and some of the members disagree with me, but I think it's important for us to take responsibility collectively for the things that have come before and the things that we leave behind. And in this instance, the Ethics Commission meeting was on January 10th, and our first decision for me based on this was on January 25th in 10054, but that didn't go to ethics the order of determination was then dated February 7th, and that didn't go to ethics until August 15th. And prior to that, there had been up on our website the possibility that we would be attempting to amend the Sunshine Ordinance and that it might be okay to attach the minutes as an addendum. I mean, to attach the 150-word summary as an addendum. Now, to me, that means that in the minutes currently doesn't provide for that, and we would have to add to it to allow it to be attached. But at the same time, it was up there at the time that this, that Mr. Hartz provided his 150-word summary, and these minutes for the Ethics Commission were approved before they received notice from that first referral on August 15th. And I don't know how we want to handle that kind of thing, but since there is a dispute and it was something that previously, for example, we had a hearing early on in 2010 with the rent board, and they came before us and then they sent us a letter saying we'll attach the minutes, and everybody said that was great and nobody complained about it. So for us to go back and make it retroactive seems problematic to me, but perhaps somebody here might want to address that. Member Costa?
To be clear, when you say January, you're talking about January 2011.
You mean when I'm talking about the Ethics Commission meeting?
Yes.
Yeah, Mr. Hartz is discussing a meeting that happened at the Ethics Commission on January 10th, 2011.
Right, okay.
But the first time that the task force had the order of determination issued related to the minutes being attached was January 25th. And then that referral didn't go over to ethics. And that was about the Library Commission. And that referral didn't go over to ethics until August 15th.
So I mean, while I think it's certainly important to be open about the fact that there had been discussion of the possibility that minutes could be attached at the end as an addendum, that wasn't an official order of determination. That was a discussion, at least for the last several months. We've been very consistent on our interpretation of this issue, and very loudly so, I would say. And I think that would be ample time for ethics to comply, essentially. And I think they've come before us previously and represented very clearly that they have no intention of doing so. So.
Member Snyder?
Yeah, so two things. One is that there's the general presumption in the law is that court decisions are retroactive, that they have retroactive effect. We're not a court, of course, and so it's always a bad, or not bad, but it's never a perfect analogy. But we could make the argument and could support it with case law that so the justification for that retroactive effect is that a court does not create new rules. It merely enunciates rules that already exist. It's kind of a fiction in a lot of instances, but it's fairly well generally applied. A decision has effect to actions that happened before it.
Can you say that again? A decision has effect to actions that happened before it.
Yeah, it has retroactive effect. So our decision to apply that here, we could argue our order of determination in February, which said you have to attach the minutes to the meeting, wasn't creating a new rule. We were just enunciating the rule that already existed that says it must be in the minutes. We were just elucidating or elaborating on what the Sunshine Ordinance already says. So we could make that argument. We could also ask, and I don't know if we have facts in the record that speak to this, but we could also ask, well, did you start complying after the order of determination did come out? And this is the point that Member Costa is making, I think, that when did it issue? February. February. So have they started putting minutes, the statements in the body of the minutes after February? I don't know. I don't know the answer to that. I suspect it's no, but I don't know if we have any facts before us that speak to that. If we do have facts in front of us that show that they haven't complied since the order came out, and we don't even need to make the retroactivity argument. I mean, technically, this complaint is based on a single set of minutes, and our decision should be based on the alleged violations in this complaint. But if we had evidence in front of us that they weren't including the statements in the body of the minutes after February, then we find a violation based on that. We could.
Well, I know they're not. They're saying that they attach them. The Ethics Commission has determined that they will attach the minutes, the 150-word summary to the minutes, and they put a link to it, and they put kind of a disclaimer on it, which is one of the reasons why I object to it being attached at the end, because then they can put a disclaimer on it that we haven't ever reviewed these, or we don't necessarily agree with these. So we know that they haven't.
How do we know that?
Because I look at their minutes every month.
Oh, okay. Well, maybe Mr. Hartz knows. Mr. Hartz, do you know? Are they complying now?
No, and you do also, because this is the reply from the Ethics Commission to you, dated November 22nd, 2011, in which they say, no, we're not going to do it.
Where does it say that? What page are you on?
I don't know if that's in our packet this time, Mr. Hartz. Is some of it?
It's 100 pages long.
Yes. Do we have the
Is
letter?
it?
Where are you looking,
164.
Mr. Hartz?
Yeah, I don't have the same reference pages because I have the copy of the actual letter. But I would like to just add this, if I could, relating to this. The statement that I'm talking about starts out with the following. The placement of this summary as an attachment to the minutes violates the clear wording of the Sunshine Ordinance. The Ethics Commission has made specious arguments to justify this variance from the law. And then when this went in, and they still continued to refuse, and then when 10054 was sent to them and they dismissed it, and 11054 hasn't gone to them yet, but I know, and I think we all know, that they're going to dismiss that too. And then they send this in November saying, well, we don't have to, and part of the reason is because you had discussions about attachments being okay. And it's like, okay, well, we also had discussions about having a $50,000 fund so we could hire outside counsel. Do we get to do that? They need to follow the law, and that's what this first statement was about. It's the ordinance says very clearly in the minutes. And it even had a statement at the beginning say, I'm attaching this, and quoted the law.
170. I'm sorry, Mr. Hartz. The page 170, section E, is where where the Ethics Commission states its amended policy and practice regarding its approved minutes. Although I am satisfied with your explanation of the retroactive effect of the.
Okay, that was what I meant in my comment, that I said they've made some changes. But
Yes.
we made some changes, but we're still not going to put the 150 word in the body of the minutes.
Okay. And then there are a couple things that this response on page 169, the Ethics Commission alleges that we violated the Brown Act and the Sunshine Ordinance by amending Mr. Hartz's order of determination in 10054 because they state that the complainant or the respondent petitioned the task force for reconsideration. But I allege that Mr. Hartz did petition the task force, and we also found that too. Just because he didn't write it in words that they couldn't refute doesn't mean that he didn't petition the task force. He did. He wrote 10 days later complaining about the very thing that we removed from the order of determination. And the removal of it did not change the order in any way. It was just the statement that Member Nee had said he might have recalled that we had allowed them to be attached before. And they're saying that that is a violation of the Brown Act and the Sunshine Ordinance. Although the way that we the way that we reconsider, yeah, they're saying that because they're saying the way that we reconsider is for the complainant or the respondent to. And my allegation when we removed it was that Mr. Hartz did complain about the statement, and his email does literally discuss the statement that was removed. There's no moving that around. So I think that when we address this, we should refute that in the order. Member Costa?
If it's useful context, I'm pretty sure at least one venue in which he complained definitely about that specific thing was at the Education Outreach and Training Committee meeting, and that committee voted to forward the case back to the full task force specifically because we wanted to clarify our stance on this. The stance of the full task force, because we were all of the opinion that it had been the nature of the original order that...
But it has to be within 10 days of the order. I think you guys are after that. But definitely...
I don't know when the order was issued.
I'd have to look at that, but I know that it is that he complained at least 10 days after, because I think it was attached to the big long part of it. Remember when we had we had the order of determination, I had brought it before compliance and amendments, and then it came before us, and we removed one sentence from it. And the sentence just said that Member Nee, that they had recalled that the task force had found that it said the task force found that we had allowed in the past the minutes to be attached. And I spent hours looking through all of the findings, and that had never happened. And we removed that sentence because Member Nee had actually said, correct me if I am wrong, but I believe this is what happened. And then it got put in the order of determination as a finding by the task force, though that was not the case. One person making a comment that they believe something happened is not a finding of a body, of any body, not just the task force. And if they allege that it is, when I go to the Ethics Commission, I'll be very careful to monitor each thing that the commissioner states, because then they too will have to accept that standard.
Given that, and I agree with your interpretation of it, that it was not a finding of the task force, and given that it was sort of the read of the EOT committee, that was a sort of misleading inclusion in the order. Would it not be at the pleasure of the committee to forward that back to the task force to correct? It still has to come as a result of a petition by Mr. Hartz within 10 days. Isn't that just sort of correcting a matter of record of the task force?
That would have been an argument we might have addressed, because it was just a correction, which is something that Member Snyder brought up. So I just think that when we decide what we're going to do here, we need to address that, and I'm pointing it out. It's on page 169. And then the other thing I think that we need to address is on page 171, section F, they say that they're not going to come to the Ethics Commission. The Ethics Commission is not going to be present at this hearing because the Ethics Commission has determined that under 6721E, they're only required to come to a hearing concerning a records request denial. And since this is about a public meeting violation, although technically the minutes are a record, they're not going to appear. And I think that they've asserted this a number of times, and they even say we don't have jurisdiction to appear. So I think that's another thing that we need to address. And under 6730, it says that the Sunshine Ordinance Task Force shall make a referral to an enforcement agency whenever it finds a violation of any section of the Sunshine Ordinance. So that's implied authority, because how can we make a finding of a violation if we don't have a hearing? So that's implied authority for a hearing. So I think we need to put that in there so that the Ethics Commission doesn't just keep repeating over and over again. And DCA 3 actually puts that argument in his memos, because he says that the Ethics Commission ignores 6730 and just goes on to other sections of the ordinance. But that's implied authority now for the hearing, so we need to address their jurisdiction. So why don't we let, since Mr. Hartz is the only one present, shall we have his rebuttal? Is that okay? So let's do that. You have 3 minutes.
Members of the task force, I appreciate the discussion. The reality is they don't like what I have to say. And I would ask you to just consider, I probably said some things to you that you don't like what I have to say, but I haven't seen anybody in this body say, well, we're gonna make sure that Mr. Hartz's idea doesn't get into the minutes, and we're gonna put in something that misrepresents Mr. Hartz's idea. And that's unfortunately what the Ethics Commission has done. I think they've shown a pattern. Yes, it may be a January request, but it was basically, I'm filing this complaint. My idea was, if I file the complaint, maybe they'll go back and look at this and say, well, we'll reconsider, and from here on, we'll go ahead and do it. But they didn't do it then. They didn't do it when you found in 10054. They didn't do it, 10054. They didn't do it when you filed in 11054. And they basically said in this letter and subsequent letters that we're just not going to do it. City attorney says we can make an addendum, and that's what we're going to do. And what they're saying in my mind is, we don't care what the law actually says. We are going to instead rely on somebody telling us that the law, instead of what it clearly says, means something else. And the only reason I can think of, and they've given at none of our hearings, or in this 150 or 143-page monstrosity, they gave no actual justification as to why we want to keep this guy's statement out of the minutes. But I think we all know the answer. We don't like what he says, and what we'll do is we'll make it an addendum. And I think also the statement that they put on the front of it when they attach it to the back of the minutes reads as follows. This summary statement was provided by the Speaker, Ray Hartz. The content is neither generated by nor subject to approval or verification of accuracy by the Ethics Commission. In other words, you can take this with a grain of salt. We're not verifying it's accurate, and it's not subject to our approval. Well, that's the one thing they got right. These statements aren't subject to their approval, just as the free speech is not subject to their approval. And the simple fact that they don't like what I and other people have to say, and when we object to the way they represent, or in some cases clearly misrepresent what we say, we choose to make use of the extra benefit that the Sunshine Ordinance provides, which is that additional protection that if you don't like it, you can put in your own 150-word statement, and it can go right in the minutes where it belongs, and that's, I think, where it should be.
The matter's back with, I just want to make sure that the record reflects that the respondent was not present, and that's why we didn't have rebuttal. Member Nee.
I want to address that 67.21E question for a second. My first question is, and perhaps Member Snyder could best answer this. What force of law does Section 67.1 have, findings and purpose? Reason I ask that is the language in Section D, subsection D, the right of the people to know what their government and those acting on behalf of their government are doing is fundamental to democracy, and with very few exceptions, that right supersedes any other policy interest government officials may use to prevent public access to information. By refusing to appear before us, even though this is not a matter of public records withholding, it is still a matter relevant to the Sunshine Ordinance, relative to the conduct of government. Could we not argue that they are at least violating the spirit of Sunshine and specifically the language in 67.1D?
I mean, findings and purpose are usually construed as sort of guiding lights for what follows, and I read 67.1 to do something similar to that, which is to say these are the sort of philosophical underpinnings of the specific restrictions and requirements that are going to come afterward. The problem with finding a violation of 67.1, so you were talking about 67.1
D,
yeah,
David.
You know, it's general language which doesn't really prohibit or require anything. It's policy more than it is law. I think it's hard to find somebody in violation of it because it's more of an affirmative statement of what the Sunshine Ordinance, or what the people of San Francisco believe with respect to openness in government. But if you're looking for authority for us to require the Ethics Commission or anybody else to appear here based on an open meetings violation, Chair Johnson referred to section 67.30 as and we've talked about this before, but this is the basis that we've often cited for it. So 67.30C discusses the task force's authority to make referrals, and it says toward the bottom of 67.30C, the task force shall make referrals to a municipal office with enforcement power under this ordinance, whenever it concludes that any person has violated any provisions of this ordinance or under this ordinance, violated any provisions of this ordinance or the acts, meaning the California Public Records Act or the Brown Act. What this assumes is that the task force has the authority to find violations of all those provisions, and in order to do that, the task force has to have hearings. It has to call people here to decide, to hear evidence and decide based on that evidence whether there's a violation. So I think we have a good basis to conclude and to argue that there's plenty of authority to require agencies to show up for violations of public meetings, not just public records.
Thank you.
Plus, it provides due process for them when we hold a hearing that they would come to. Is there a motion? Should I make it? Anybody? All right, so I move to find a violation based on our jurisdiction under 6730, the implied jurisdiction in 6730C. And our prior rulings regarding the 150-word statement in the minutes I move to find a violation of 6716 for not including the 150-word statement within the body of the minutes, and 6721E for failure to appear.
Second. Is this against Mr. St. Croix? Or
This, oh, thank you. Yes, he's named as in the complaint, so John St. Croix.
and where would it be forwarded to?
I would forward it to compliance and amendments. Is there public comment on the motion?
Sorry, my foot fell asleep. David Pilpel. On my read of this matter, which it seems has been around for a few months now, on page 170 of your packet, subsection E that you discussed a few minutes ago, the Ethics Commission has amended its policy and practice regarding its approved minutes. So to the extent that there was at all legitimate concern that the not to exceed 150 word statement was detached from the minutes, it appears that they have changed their practice so that they will not be detached. As you indicated, the plain language of 67.16 is that any person speaking may supply a brief written summary which shall, if no more than 150 words, be included in the minutes. The language of the ordinance does not say included in the minutes at a particular section or in a particular way, just in the minutes. I believe that to find that they need to be included in the body in a particular way, in a particular format, goes beyond the language, and that departments, boards and commissions, policy bodies have some discretion for how to include the not to exceed 150 word statement. The guidance from the city attorney's office has been consistently since 1999 that bodies may include the not to exceed 150 word statement in the minutes with whatever caveats they wish to include, but that they must be included in the minutes or as an attachment, but as a part of the minutes. It appears to me that the Ethics Commission has done so consistently, continues to do so in varying ways, and I have their agenda from their meeting last night, including the minutes from the previous month's meeting, which include at the end, as part of the minutes, statements provided by speakers not to exceed 150 words, including reference to the agenda item on which they spoke and with a caveat. I believe that there was no violation here. I am not addressing the issue right now about whether the task force has jurisdiction over complaints alleging a violation of the public meeting section, but I, in any event, don't believe that a finding of a violation is in order at this time. Unless you have questions, thank you.
Thank you. Is there additional public comment? Okay. Seeing none, public comment is closed. Mr. Pilpel reminds me that I need to possibly reword my motion. I said based on 6730C, the implied jurisdiction in 6730C, but I also think that we should add our former language in there and the task force interpretation of in the minutes, so that we can add that into the order again, because we don't interpret in the minutes to include attachment when no reference to an attachment has been made. Does the second accept that?
Second accepts.
Based on that. So then, Andrea, it would be based on the implied jurisdiction in 6730C and the task force interpretation of the phrase in the minutes.
So is it a tangential point, but I just sort of want to make it just for the record. I think that it came up at a previous meeting, similar topic, same topic, but a different case, that actually it wasn't the case, that the city attorney's office has had this same position since 1999. They actually were advising in the minutes more recently than that.
Yeah, it's.
I don't have the exact here, but I seem to remember this sort of being in a point of discussion, and I just wanted to at least raise doubt about whether or not they have indeed been consistent on their interpretation of it since 1999.
Well, we can only go by the good government guide.
Right, but I believe the guide itself we found that it had changed more recently than 1999.
Yeah, it changed in 2007.
Yeah, that's what I thought.
From 2006. Okay, so is there any public comment on the change to add the, I guess that's not really a change in the motion, is it? It's just the basis of our, okay. So can you call the roll on the motion?
On the motion as stated, Member Snyder?
Yes.
Member Nee?
Aye.
Member Monet?
Aye.
Member Costa?
Aye.
Member West?
Aye.
Chair Johnson?
Aye.
There are 6 ayes.
So the motion passes, and this is referred to compliance and amendments. I have a second. I don't know, do I need a motion? I have a second motion because on page 169, I would like to move that we write a letter to the Ethics Commission stating we did not violate the Brown Act and the Sunshine Ordinance. Do you feel like we need to address that?
Second.
Or no? At
I
this
don't
time?
know. I think the question is, what force, if any, does their conclusion in this letter have?
Okay. So for now, I'll withdraw my motion because we might be able to come back to it later.
Yeah. I mean,
For the second.
I don't know if it's necessary to engage that.
Okay.
It may be. I mean, it may be that they're threatening something there and that there's actually some authority and they're going to pursue something with it. But if this is just their opinion thrown into their letter responding to us, that's their opinion. And I don't know that it's necessary to engage them on it.
Okay. I'm withdrawing my motion. Does the second?
Sure.
Okay. Okay, so the matter is concluded. Can you please read the next item?
Item number 13, file number 11089, determination of jurisdiction on complaint filed by Bob Burkhead against the City Attorney's Office for allegedly withholding documents.
Is the complainant present? And the respondent is not present. Have we heard from the complainant or the respondent?
No.
No? Do we have a preference on how we want to handle this? Do you want to continue it, or do you want to?
Madam Chair,
I'm sorry, member Nee?
move to table.
Okay, so the tabling would mean that if it wasn't on the next, if we didn't place it on the next agenda, it would die for a. No, tabling is if it doesn't then, if we don't then take it up on the next agenda, it dies for lack of an action. Isn't that what we ruled here before? And otherwise, we dismiss it with the.
I believe so, and we would have to, obviously, we would have to notify the complainant and the respondent that the matter has been tabled, and if it's not brought back at our next meeting, it dies.
Because at some of the other meetings when people did not appear, we've dismissed it with the caveat that they have the right to refile. Do you prefer to table? Okay.
I think tabling would be appropriate, tabling till April 4th, because there's only a week between now and our next meeting. So I would say table to April 4th. That's my inclination.
Okay, is there a second?
Second.
Is there any public comment on the motion to table? Okay, seeing none, the matter has been tabled, but to April 4th, and we'll have to notify them, the respondent and the complainant. Okay, can you read the next item? I think it's 19.
Item 19, file number 11093, determination of jurisdiction on complaint filed by John Darmain, Dominan, against the Fire Marshal Thomas Harvey for allegedly not releasing several internal documents.
Is the complainant present? No, the respondent is present. Okay, since the respondent is here, and the complainant, did we hear from the complainant?
He said it would be present.
He said he would be present?
I have nothing saying that he would not, so.
Madam Chair?
Mr. Darmanin, did you see the complainant tonight at all? Are you familiar? Oh, I'm sorry. I'm trying to do many things at once. I'm reading things. I apologize.
The gentleman seated.
Mr. Harvey?
No, that's not Mr. Harvey. I don't think that's Mr. Harvey.
That's Bond.
That's Rob Bond.
Did you see the complainant, Mr. Darmanin, tonight? No, I did not. Okay. Just in case we didn't, the respondent who was present said he did not see him, just in case it's down on the tape, because it wasn't in the mic. I don't want him to have sat here the entire time, so I would like to either dismiss this, or there's the issue that is on here. There was the respondent made some reference in I don't know exactly what page it's on, but I could find it, that it's on page 264 of our packet, that their rights under the Sunshine Ordinance are slightly different from their rights as an employee. And I don't know if we want to move forward to hear from the respondent about that aspect of the case. Member Nee?
Well, my inclination is that since the complainant is not here and did not contact us to say he would not be here, my inclination would be to dismiss the complaint with the opportunity to refile.
I agree.
So move.
Is there a second?
Second.
Is there a public comment on the motion to dismiss with the opportunity to refile? Seeing none, public comment is closed. Can you please call the roll on the motion? Can you wait for 1 minute before we do that? The problem with that is if he refiles it, we'd just be stuck sitting. It would be like we continued it almost. Well, not necessarily, though. We would start the clock running again.
If he refiles.
If he refiles.
Okay. Can you please read the? Thank you.
So, on the motion as stated, Member Snyder?
Yes.
Member Nee?
Aye.
Member Monet?
Aye.
Member Costa?
Aye.
Member West?
Aye.
Chair Johnson?
Aye.
And 6 ayes.
Okay, so this is dismissed with the opportunity to refile. I appreciate your being here. Thank you. I'm sorry I called you the wrong name a number of times. Could you read the next item, which is item 24?
Item number 24, report Education Outreach and Training Committee meeting of February 9th, 2012.
Member Costa?
So it's been a while since we've had the opportunity to give a report. I guess a couple of the most notable things are that we have started implementing the new press release system. The way it's been working is I've been sending them out right after meetings. That was the vote of the EOT committee in terms of how to handle it, at least for the time being. And I haven't seen any articles resulting, but we have been getting a decent percentage of opens on all of our emails. So
Okay.
we have a list of about, I'd say, 40 or 50 media contacts who are sending them to. Something else that we discussed at our last meeting was the issue of starting to do some more outreach to agencies themselves, and basically trying to establish contacts in terms of like who is actually serving as the supervisor of records in each given agency, to just get to know them and get to know their best practice or their practices, essentially. Just kind of being more preemptive about being a resource, and clarifying the way that we're interpreting things so as to avoid violations instead of just always responding to them. And so sort of to that end, we discussed the possibility of, we just started a new kind of press-oriented initiative. We have an agency-oriented initiative. And so maybe, thinking as a committee about how we want to divide up the things that we'll be working on. And so that's kind of an active discussion that's happening.
Thank you. Can you read the next item, please?
Item number 25, report compliance.
Oh, I'm sorry. Is there public comment on the education outreach and training report? I apologize.
If I might tack something else on them, Mr. Popel was at our last meeting and provided some really helpful commentary or insight as to former practices of that committee, and so thank you again to him.
Yeah. Seeing no public comment is closed. Now, Ms. Osbury, could you please read item number 25?
Item number 25, report compliance and amendments meeting of February 14, 2012.
Chair Washburn is not here this evening. I don't know if anybody else from Compliance Amendments wants to add anything, but we are trying to schedule a hearing with a joint meeting with Ethics Commission, and Mr. St. Croix has informed us that it may be moved out to April because he's having a hard time getting the commissioners available for the 23rd. And then Mr. Grossman is gone from April 16th to May 5th. So that's what's going on there. Does anybody want to add any member need?
Yes, we also began to talk about what we should be doing to move forward the amendments to the ordinance. And some of us have agreed to make various and sundry contacts, particularly with certain members of the Board of Supervisors, to see if there is a possibility of getting 4 supervisors to sign off on the to sign off on a package to get it up on the ballot for November 2012. There is a recognition that in doing that, we risk some efforts by some members of the board to weaken what we put forth, and we may decide ultimately to take the matter to conclusion with no action and hope that a citizens group will take up the gauntlet and move it forward by collecting signatures for a ballot initiative.
Thank you. Is there public comment on the compliance and amendments report?
David Pilpel. My understanding is that the Ethics Commission was actually looking for not just one, but a number of possible dates from the task force as to when members or a majority of the task force would be available for the proposed joint meeting. So I'm hoping that it's not just limited to March 23rd, which may or sounds like may not happen. You may determine that in part on Member Wolf's return. I don't know. I am certainly hoping and encouraging that this joint meeting, happen in our lifetime, in all of our lifetimes. Unless I can provide any further anything. Thank you.
Is there additional public comment? Seeing none, public comment is closed. Ms. Osprey, could you read item 26?
Item 26, report Technology Committee meeting of February 10th, 2012.
Vice Chair Wolf is not present. I don't know if one of the other people want to say anything about the Tech Committee meeting.
Jackson, would you like to say anything about the Tech Committee?
Sure.
Could you talk into the microphone so she can?
Yes, unfortunately, I'm not sure I'd say anything particularly cogent at this hour. Yes, I think at the tech meeting, it was essentially resolved that we needed to divide our efforts in terms of the labor on some of the projects and solutions we wanted to work on, and that the first goal was some sort of hackathon, if I'm not mistaken, to address the need for a database of Sunshine Ordinance Task Force rulings, both for our own reference, the reference of the public, and potentially to find patterns of abuse or disregard.
That's also a really good idea, so that we have a better idea of what we've said before. I can't tell you how many times I've wished I could quickly draw up, pull up something to say, I know we did this, we did something on this before, but it takes forever for me to go into my own files and dig it up.
Something that struck me actually on that point tonight, is just sort of running through my head, is that the way we've been talking about it is as a database of orders of determination, which is certainly a lot better than what we have now, which is nothing. But it seems like there's also sort of a lot of valuable information that could come from really pretty much every consideration we make if we decide not to find a violation on something, too, our logic behind that. And so that's a much harder problem to solve, but it might be worth sort of at least letting kick around the back of everybody's head whether there's some way we can solve it, because it seems like there's some useful information there, too.
I have one question about it. Did you guys decide to meet on call?
Basically, yes.
Okay.
And we set sort of a loose goal of making considerable headway on this initial database in a couple of months, in the span of a couple of months. And so I'm not sure with developments with Member Wolf whether that will stay on track, but that was the goal that we decided upon.
Okay. Can you please read item number 27? I'm sorry, is there public comment on the Technology Committee report?
David Pilpel, I'm sorry I was not at this meeting. I had a conflict, and I'm sorry that I also missed the creation of the Technology Committee. My further understanding is that staff may not be able to provide administrative support to the Technology Committee. I am concerned that it's important to have that staff support, and I am not sure if the full task force considered other ways to address technology concerns short of establishing a separate committee. So I would, again, for the first time, encourage the task force to think of other ways to address this if this could be handled through one of the existing committees rather than creating a new committee. I'm not disputing that technology is a concern both for the task force and for the city, but I'm not sure that it merits a separate committee. So I'd ask you to consider other ways to address it. Thanks.
Thank you. Is there additional public comment? Seeing none, public comment is closed. Can you please read item 27?
Item 27, Administrator's Report.
Do you have anything to report other than what's in there?
Well, other than what's in here, the report starts from the day I started in the position of February 6th of this year. It just has the attachment of the current log as designed from the previous administrator, and also a call or email log on the last page of 284.
Thank you. I did just want to point out quickly that I told and Ms. Osbury something that I had noticed in the complaint log, and I don't know how we're going to address it, but I just wanted to point out that, like, for example, 11050 doesn't, it has a list of dates like July, but it was never put on a draft agenda. So I just want to point out that some of those dates might be off a little bit. Is there public comment on the administrator's report?
David Pilpel, a couple of items. I saw the 2011 complaint log in here. I didn't see the 2012 complaint log. I would assume that since the beginning of January, some complaint might have been filed. Hard to tell. I would also suggest, as the new administrator takes over and is sorting things out, this might be the place for a periodic report on sort of finding things. My understanding is that not everything was in as good order as we might have hoped. So perhaps hearing periodic reports on how the progress is being made to unbury things would be helpful. I understand that there continues to be a complaint backlog, and I'm not really addressing that as much as sort of the mound of stuff that presumably is in the office. Thanks.
Thank you. Is there additional public comment? Seeing none, public comment is closed. Can you please read item number 28?
Item number 28, announcements, comments, questions, and future agenda items.
Madam Chair?
Member D.
The Society of Professional Journalists Northern California chapter will hold its annual James Madison Awards dinner honoring champions of sunshine and the First Amendment on Thursday evening, March 15th at the City Club of San Francisco. For information, www.spjnorcal.org.
Great. I have one thing that may be a future agenda item, or maybe one of the committees like Education Outreach might want to take it up, and that's Mr. Petrellis in his blog, I forget if it was yesterday or today, made a reference that the nonprofit meeting announcements are stuck in a big giant binder in the library, and that perhaps the task force or the clerk's office might take it upon themselves to post them online, which I think is a good idea. They're just in a great big binder all stuffed together. So I thought that might be a good idea. And then the other thing I wanted people to consider, since we're not discussing it now and I don't know exactly how it might play out, but what if the Sunshine Ordinance had its own guidelines? I mean, then what if the task force had its own guidelines to the Sunshine Ordinance? Like the Good Government Guide, except the Sunshine Ordinance Task Force Guide to the Sunshine Ordinance. Member Costa.
This is something we've talked about a little bit in EOT, actually, about maybe not necessarily having something as permanent or I don't know, as binding, I guess, as a guide, but maybe something like a wiki.
The guide is not binding.
As binding, as giving the appearance of being binding as a printed guide, but at least some sort of, if we could start to collect in one central place things that we see coming up again and again and again, and we could just spell out in plain English, this is how we're finding on this.
So that's something that you guys might be working on.
Yeah,
We've talked about it. It's good. I mean, it's good to hear that there's interest.
Not to speak over Member Costa, but a good place to start would essentially be to identify questions about sunshine that come up incredibly often, frequently asked questions even, and then just addressing those, and then maybe going from there.
Great.
Yeah, it might be helpful and instructive to mention areas where we have had disagreements with the city attorney's office. And what comes to mind immediately is the question of providing electronic documents in their native formats. This is something, they say it's okay to give somebody a PDF, and we say no.
Okay. Oh, is there public comment on the item?
David Pilpel, I have no objection to this, and I think that this may actually make sense. If someone introduces an item at this time on your agenda and you formally agree to refer it to a committee, as I would suggest that you do on this matter, I would also suggest that you maintain, if one, or start if one does not exist, a pending list of items referred to committee so that it's clear that you talked about having a task force guide to Sunshine, referred that to EOT on this date, and that it is pending at EOT, presumably for a hearing and discussion at some point in the not too distant future, and that way items won't just come up here and I seem to remember a few months ago we talked about blah, 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 and then they just disappear, but that you'll actually have a place to park them and track back. So I suggest that practice. Thanks.
Thank you. That's a good idea. I think we would have to have it say action then on there too, right? To refer it. Is that true or no?
I would suggest that introducing an item and referring it to committee is not a substantive action in my view. So I think all you're doing is just putting a place and saying that we may talk about it in the future. That's all.
Okay. Public comment is closed. So I move to adjourn.
So move.
Happy birthday to Chair Johnson.
Thank you. And is there a second?
Second.
Not to my birthday, but to the the meeting's adjourned.
Oh, I could have made you.
I went to work and they had like 50 cats all over my
Oh my
office.
God, how cute. I made everyone.